That is also stage vacated. So
I just give the memo.
I only everything will also be directed list.
I'll just check.
This 21, your lordship said.
Yes, I'll check it.
Listed.
I'll check it up. Yes, yes.
I have filed a memo in a similar matter I had earlier mentioned. I will not come together.
No, in fact, what we are following is serially we are trying to list all the matters. And the unfortunate thing is, once matters are listed, people are asking for adjournment.
Some matters not there, the courts are not granting time. That is your difficulty.
And because of that, what you look. So because of stage vacated, so now all has to be, there has been reversed now. So
But
now,
once you jump the queue, then the entire system is getting jumbled up. So that's the reason. Anyway, we'll try.
Fresh Belgium.
65 or 69.
Yes.
And take 2 p.m. compromise you have to package.
Yes. No. Yes.
65
Yes. Yes, yes, no problem. All compromise matters, 2 p.m. Yes. Yes. Any mentioning? Mentioning? Yes.
Item 1.
I was conducting this matter. And I was conducting this matter, item number 1.
Yes.
And in the meanwhile, I have changed my side. Should I kindly adjourn to next week or week after?
You are now forbidden to do it, okay. Somebody else, you have to write a letter to your client.
Yes, sir.
He can engage someone.
Yes, sir.
Mrs.
Subbalakshmi Devi, Your Worship. Subbalakshmi Devi.
Yes. So submitted that she has been conducting this case. However, she has been appointed in the Government Council. Hence, she would be informing the same to the to his clients, to her clients, at least the matter. Yes.
Item 2.
Much
Similar matter, item number 1. Let it come next week. That will have
Similar matter means the same problem.
Yes. One ekka matter.
Corrected matters.
I'm the counsel for
One is what he says.
I'm the counsel for the petitioner in the item number 1, my lord. The same FIR by which
You are for petitioner.
yes, ma'am.
She says.
Item 2.
and he is the petitioner in the item number.
No, in the item 1, there is no sub-item. Item 1, she has said that I will pass the order. What about item 2?
Item 2.
Yes.
Item 2.
Petitioner number.
Yes, you tell me what is this matter?
That's
Yes.
so that CRLMC 891 of 2024, my lord.
Yes.
On the petitioner, my lord.
Yes.
This is the same FIR, my lord, which has been instituted by the Tehsildar based on a NGT order, my lord, which has already been quashed by the Honorable High Court.
That the NGT order is passed.
Yes, my lord.
Yes.
So,
The
lordship,
same is the story there in item 1.
my lord, here the petitioner order the counsel.
Item 1 is different, yes. Why are you confusing 1, 2? This is item 2, yes. Yes.
In this petitioner, in this case, my lord, the company, it was a company who was holding the license for the
What is the offense?
offenses are under sections lordships. There's 379, 420, 403, 120B. The petitioner is a director. The company has not been
In the 420, how it is relatable?
Lordships. The lordships and that along with lordships, rule 12 of Orissa mining mineral theft control.
That offense might go, but in so far as the other offenses are concerned, it has to be tested.
Yes, my lord. I'm not saying that. Lordship. What's the problem in this matter is, lordship.
Yes.
The petitioner is the director of the company.
Yes.
What the NGT order says, my lord. Lordship may kindly
Only the NGT order.
Yes, my lord. Page 72, my lord. That's a relevant part.
Yes.
By which the FI has been lost, my lord.
Yes. Come to 72.
Lordship may kindly produce para 50.
Para?
50, my lord. That's operative part.
Okay, 72. Okay. Yes.
You read, my lord?
Yes.
The state respondent shall also initiate criminal proceeding against the Tehsildar Sri Jugal Kishore Mishra, OS retired, Sri Sanjay Kumar Samantray, OS, and the additional Tehsildar in charge, the Ashok Kumar Patnaik, who is also a petitioner before my lord. ORS, concerned revenue inspector, revenue supervisor, DE assistant, section officers as disclosed in the
Unilaterally taking decision of auction of queries ignoring so and so.
Yes, my lord.
Yes, and okay, the okay, understood. Pursuant to this order only the FIR has.
Yes, my lord.
There is a specific direction, but
Yes,
the
ma'am.
NGT which has now been set aside. That's
My
not
lord.
their case.
My lord, please.
And after setting aside this NGT order, whether anything is filed.
So far, my instruction goes, my lord, it has not been filed. It has been decided by the High Court to take a fresh to
Where is the High Court order?
Yes, my lord.
Yes,
My lordship, relevant para,
that is annexure 5, I believe.
Yes, ma'am.
Yes, come to it.
page 92, that starts with page 92.
Yes,
Relevant page 102, my lord.
102.
Yes, my lord.
Yes,
May I read, my lord?
yes.
Considering the submissions made by the learned senior advocate, appearing on behalf of the petitioner, looking into the factual and legal aspects of the case, the court finds that the committee constituted by the NGT has violated the principle of natural justice by not affording the petitioner an opportunity of hearing. In such view of the matter, while setting aside the interim order dated 18/4/2023, the same order, my lord,
Yes.
under Annexure 2,
This could.
This court limits the matter back to the NGT Eastern Zone Bench, Kolkata, for adjudication of issues afresh. It is also made clear that the committee constituted by the NGT Eastern Zone Bench, Kolkata, shall afford the petitioner reasonable opportunity of hearing first, and thereafter the NGT Eastern Zone Bench, Kolkata, shall pass the order in accordance with
This is regarding the constitution of the committee and all. Who was the petitioner in NGT?
Yes, my lord. The petitioner was the one of the villager, my lord, who filed the petition before the NGT.
Yes. No, the High Court says that it is violation
Yes, my lord.
of natural justice and all.
Otherwise,
Magic indicate that you being the accused against whom the orders are
My
passed,
lord.
they were not heard. Is it
Yes, my lord.
indication of that?
yes, my lord. That's
Have you challenged that the NGT order there in the High Court? You
Yes,
have
my
not
lord.
challenged.
Yes, sir.
Who challenged the NGT order?
This is Agarwal informant, my lord. The OP 18 in the NGT order is Agarwal informant, my lord.
Who are you?
I am the director of the company.
Director of Agarwal?
Yes, my lord.
Okay. Understood. No, I understood. What do you say?
Not the other two connected cases are there staying in
Yes.
the form first aid.
So there is nothing, I have to cross it. Because see, the entire case is based on the NGT direction. And they were aggrieved by that. The company had gone to the High Court. And High Court says that it is a violation of principle of natural justice. Therefore, the NGT order is set aside and remitted back to the NGT. Then the entire basis for initiation of criminal prosecution will go. So I'll cross it. Why should we wait? What do you say? There is nothing. Unless you say that you have challenged the order of the High Court before the Supreme Court or anywhere. You have accepted this order.
Unless that is unless it is not been challenged and not certified, it is binding question.
At 2 o'clock, you tell me whether you have challenged this order or you have accepted it, because it's a matter of it is only remitted there. So if you have not challenged, then I think you don't have a case.
No.
Come and tell me at 2 o'clock.
Rule 14 itself says no criminal proceeding can be initiated, only civil proceeding can be initiated. That is the rule 14 of the NGT Act.
NGT.
Married.
Yes.
The tribunal followed the jurisdiction over all civil cases.
Yes.
Where a substantial question is relating to environment, including enforcement of any legal right relating to environment, is involved, and such out of implementation of the enactment specified in law.
But come to the FIR then. Whether the FIR is on the basis of the report.
On the basis of order of NGT.
Where is that? Where is that?
For that, my lord, Lordship may kindly come to Annexure 3, my lord, case 74.
Yes.
Yes, my lord.
Yes.
My lord, to IIC Chandpur PS Nagar, lodging FIR against respondent number 17 and 18. I am the director of 18, my lord. See Sushant Kumar.
It says that pursuant to the direction of it.
File OA number so and so, read with so and so, order dated the 25th
Mr. Jana just seen 74. It is pursuant to the order of file. 2 p.m.
In this case, my petition, my clerk is not a party in the NGT. ইনভিটিগেশন পাচ্ছি নাহি কিন্তু
It's all right, but the first matter, he succeeds in the first matter, the ultimately, the second matter also goes. Yes.
If I may be permitted, item number 18 is also based on the same facts and circumstances.
18,
Yes.
18 also you take it, take 18. We will finish it up unnecessarily, these matters are pending. 18 also. You just tell me whether you have challenged that order of, see, I don't think you might have challenged, because see, High Court only says that principle of natural justice violated, so therefore remanded back. So you must be contesting. If again same order is, but I'll record it for Kasi, that will not preclude the state to prosecute if anything else comes in the remanded proceeding. In the remanded proceeding, suppose the AGT says that he is same thing.
That's obvious.
Then you can't preclude.
That's an obvious conclusion, my lord. If something new comes into the picture, my
So
lord.
I'll just record that. It will not preclude the state to prosecute if anything comes in the AGT direction.
The fresh proceeding
Yes,
is
proceeding can be. But this, insofar as this FIR is concerned, I'll watch it.
grateful, my lord.
Okay. Yes, Mr. Jana, now I understood. Yes, 2 p.m.
Grateful, my lord.
Shall I put it tomorrow? If it's better to put it tomorrow. Why to pressurize him? You will not get time now. When you will go in contact. We'll leave it tomorrow. Yes.
Grateful, my lord.
18 also tomorrow.
I know that.
This matter to not.
In between, I don't entertain, you know.
But I will just communicate about it.
There you have been standing, I have seen it. When item 1 was taken up, but before that you were standing, yes. Don't repeat it in future. Yes. All right, yes.
Okay, so it could not be listed. Stay order was still 20. That matter.
See, it was listed on 24th, in lieu of that holiday. 30th is the date taken. All the matter will be taken up on 30th.
Your option may remember that matter was pending and the CRLMC in the 125 was saying whether the point is whether the maintenance should be one.
So where is that? Have I said that it is till 24th only?
Yes, that check. It's still 24.
And they have given intermodal. This, so me and if it is that is the case, then release it to tomorrow. Release it tomorrow. If the date is given. If the date is not given, I will come on that day.
First day, interim order till then, put up on 24th along with Mata number shuttles. I checked up and I mentioned, but I am not at least.
No, if it is, I list it if it is otherwise, then I will vacate it. Okay. I'll check it. Yes. We list it only for extension of interim order till 7th. Till 30th. Yes. Tomorrow. Just 1 minute, please. 1 minute, what will be taking out the order? Acha, till next date appear. List it tomorrow.
But at least your option should be well assured, at least from my side.
No,
For submission.
It's all right. Thank you very much. Yes. Yes.
Item 3. Item 3, my lord. For release of the vehicle, which was seized in connection with my lord, offense under section 52A of the Orissa Excise Act.
Yes.
Allegation of carrying the liquor in a motorcycle.
Yes.
In the meantime,
Where is the interim order, sir?
one is the passed by the one is JMFC.
And regional order is 2.
Answer 2. In
Yes.
meantime, what happened? They confiscated the vehicle.
Yes. You will find letting very nothing.
I will file up.
Hmm?
Silly, but in the
Yes.
meantime, I accepted by
Yes, petitioner is agreed by the order judgment dated 26/12/2023, passed by Sessions Judge Nagar in criminal revision number 7 of 2023, whereby the order dated 4/10/2023, passed by JMFC run for on the application of the petitioner under section 457 CRPC has been upheld. Mr. Dwivedi, learned counsel for the petitioner submits that meanwhile, confiscation proceeding has already been concluded and the vehicle in subject has been confiscated. He seeks liberty to withdraw this matter to agitate the issue before the competent court against the order of confiscation. With this liberty, the petition is disposed. Yes.
Item 4.
Yes.
Minutes here. The petitioner is the wife of one. His husband has been involved in a vigilance case under section 13(2) 13(1)(e) of the case.
Yes.
Your worship will kindly turn to page 62.
You are the wife.
While submitting the charge sheet, he said that para and pressing last para.
You are referring to 52, page 52?
Let's press 62.
62. Okay. Yes.
That charge sheet.
Yes.
Charge sheet.
Yes.
As there is ample evidence of section 13(2) reduced section 13(1)(e) of the Prevention of Corruption Act, so against the acting practices of some of who is now retired from government service, government service and against his wife for activity. So no reason was there is no in the entire charge sheet, there is no involvement.
Against his wife for accumulating disproportionate asset.
I am covered by a judgment of your worship. Similar case.
109. 109.
Yes. Similar case.
Yes. But you have a defense. That's the problem. You have a defense of your own. If you have a defense of your own, then you have to face the trial. That's the distinction.
I am no way involved in the case.
But if you are trying to justify the assets, then you are it.
I am not going to try to justify the assets.
60.
60.
Yes. Yes.
Explanation of plea of accused.
The accused is particular to the plea.
Took the plea, land, building and other assets. All land and building stands in the name
And the name of his family
the
member
name of the family member.
have been acquired by him.
From his salary,
Then income
house rent income, house rent and income from agriculture. He also claims income received from his two employed sons staying abroad. His wife, Srimati, the petitioner.
He's a housewife.
Except house rent income and income from Bharati Airtel Towers. She has no other income sources. Srimati Jhuna's wife of the accused claims that her father and her in-laws helped them during construction.
This sentence is problematic for you. The judgment cannot be, utilized for your thing. If you put forth your own defense, saying that I acquired from this source, that source, then you have to prove it. Had it been the first paragraph of this, you are directly covered by the judgment. First paragraph, the husband says that all the assets in the name of the wife has been acquired through my income. Then it is he who has to prove it. But once the wife comes out and says that no, the part of the property or the entire property is acquired through X source or Y source from my family or my business, then that part of the things has to be proved by the wife. So that is
tomorrow I will find out whether wife's statement is there or not.
That is the second.
If it is not there in the charge sheet.
She simply says that that her father and in-laws helped them to during the construction.
If her statement is not there in the charge sheet, how can it be there in the final charge sheet? You have not been examined.
You satisfy me. Otherwise, the first paragraph you are directly covered.
The law has also, but if unless the wife has been examined, such a thing would not be there.
Whatever, you have to check it. You have to tell me. Because the first paragraph you are covered, the second paragraph you are in.
You have to keep it to tomorrow.
Not tomorrow, I'll put it next week. I put it on 14th. 14th.
All right.
Yes.
13th, yes.
13th, okay. Yes.
Item 5.
Very clear.
Yes, sir.
My lord, here is a case. I should say, my lord, it's a unfortunate case, my lord, in the sense. I have challenged, my lord, the order taking cognizance passed by the special judge, vigilance, my lord, in taking cognizance against the petitioner for offences punishable under section 13 and other allied offences.
Yes.
As it is, my lord. This is a case, my lord, the petitioner, one man, my lord, after completion, successfully completed his career as PD, his service was extended considering his honesty, integrity, and my lord, everything. It was extended twice, which became eyesore of many persons, many all the officers, those promotions were pending because of or held up because of
the extension.
But before one day before his retirement, my lord, again, my lord, I'm just drawing my lord's attention, which is there in the charge sheet. One of his son is a colonel, two sons, my lord. One of his son is a colonel, and the second one is an IT engineer in states, my lord. My lord, he was coming with rupees 2 lakhs to deposit the same in iron and builders, my lord, because before his retirement, at least 2 BHK, 3 BHK would be used. On the way, he was intercepted. The tips the vigilance people got from the office because he had obtained loan from 2-3 persons, my lord, to have that money and to come to Bhubaneswar. On the way, he was intercepted and rupees 2 lakhs was recovered from him. This is a case of 2015. After the incident, they tried their best, my lord, to find out at least 1%, 5%, 10% DA. They could not get till they submitted charge sheet in the year 2024.
Yes.
9 years they took to put him, my lord, in DA, but they could not.
The final form was filed.
My lord, ultimately 2024 final form was filed, and it is, my lord,
17/10/2023.
My lord.
Yes.
And ultimately, my lord, cognizance was taken in the month of September.
On the final form.
On the final form. What I want to say, my lord, their case is that I could not explain how I got the money. My lord, they have examined 2 persons. My lord, may kindly say I have given 161 statements of the witnesses. From the very beginning, I was saying, my lord, usually, my lord, to add number to their role. This sort of vigilance cases we have installed. My lord, when we see first page 30, the statement of the present petitioner. He has categorically stated that I have obtained loan of rupees 2 lakhs from 2 persons. My lord, may say page 30, I have page
130, yes.
30, Rajkishore Acharya statements.
From Chakravarti Mahakut.
Yes. Then, my lord, it is to be seen whether Chakravarti Mahakut had got that guts to say before the vigilance authority that whether he has given one Chakravarti Mahakut and one, my lord, Surgeon Hembram. My lord, we see page 17.
17.
Chakravarti Mahakut has been examined and how he said.
Yes.
More than Chakravarti Mahakut, Pita so and so, all over the Janan, go upon the number of Jamikurico, Jambira project, Padimuru, Ambe, Munisa Rabbe, Nove, Bayan, Mosiere, Poisa Paitilo. He was a rat Mosiere, so and so. He said, I have paid 1 lakh because.
But it's all right, but
let me see. Next ballot, page 18.
18, yes.
Sanatan Hembram, he says, I have paid 1 lakh.
Hey, that's right.
My lord, 2 lakhs have been recovered from me.
And that you justified explaining that.
What is the case?
But that's right. But can I in this proceeding,
my lord,
appreciate the statement made by the accused and witnesses under 161 and
my lord, what is to be appreciated in the case before when at the stage of cognizance? When, my lord, when we are arguing a case, we are referring 161 statements, and which law is very clear that we cannot raise our defense. No, my lord, this statement.
Parents charge will not be framed against you.
Well, no, my lord, they have submitted charge sheet and non-license. The question of charge, well, why a old man of retired woman?
I have all the sympathy, but the problem is having at the cognizance stage on the basis of one which one I agree.
Stage of cognizance, kindly say. At the stage of cognizance, what the court will say? Accepting the entire case of the prosecution if no case is made out. Without accepting the defense. Or the court will not see whether the accepting the defense of the case will be ended in acquittal. I am here, my lord, in one of the best cases, because I am having a career of 45 years. I don't have a house. I don't have a vehicle.
I know I have house.
I am 2 lakhs. 2 lakhs is nothing nowadays. That 2% says he, what do you say?
Your lordship kindly see page 27 of the charge sheet.
27.
How the petitioner stage managed, your lordship kindly see.
State managed.
Yes.
Para 2.
Para
2.
My lord.
yes. Thereafter.
Interception upon perusal of the non-personal source of this petitioner found one Microsoft telephone number so and so purse 670. On request, Acharya brought one brown color airbag which was searched in presence of the witness. During search, 3 pairs of pant shirt and cash 2 lakhs. 3 bundles of 500 rupees GC notes, total 1,50,000 टंका, and your lordship kindly see the serial number. All are serial number. 9,001 ରୁ 9,200, ତାପରେ ଆଉ ଗୋଟେ ବଣ୍ଡଲ 301 ରୁ 400, ତାପରେ ସିରିୟଲ ନମ୍ବର ତାପରେ ଯୋଉ 5ଟା 100 ଟଙ୍କିଆ ବଣ୍ଡଲ ସେ ହେଲା ସେ ବି ସିରିୟଲ ନମ୍ବର ସମାନ ଅଛି. On investigation being asked Rajkumar could not explain the position of huge cash with him. He has also not withdrawn the amount from any bank. And the verification last para your lordship can. The salary account of Rajkishore Acharya was maintained at SBI branch Bhubaneswar, and the account statement of shows that there was no withdrawal till date of search, and no such huge withdrawal was found during month of Baripada AD. Into that, on verification with RBI, investigation proceeded to RBI, they clarified Union Bank of India Baripada branch to someone केबे रिलीज करथिले ये लॉस कैंडी सी नेक्स्ट पे सेम नोट and 3/4/2015 prior to ये 18/4/2016 रे केस. The money now they are claiming that the land was sold and my mother has kept the money and I have given it, brought that money and given it to him by the contractor. That was the land was sold a year back and that money serial number was available at that point of time. You will also imagine. Then serial number the bank RBI issue for
500 serial report so rupees were received branch up to 29/4/2015.
My lord. अभी विक्री सारी पैसा আছে টাকা পাখারে.
My lord, I will make kindly see the statement of
bank to whom the LA series
Sergeant Himram.
on the examination of Siddharth Kishore is told that he has received.
And see what you bank में उठे गए.
सीरियल नंबर 3टा सब जगह सीरियल नंबर से उठे
बैंक में आने तक सीरियल
ପରେ ପରେ ଉଠେଇଛି ସରକାର RBI ଇସ୍ୟୁ କରିଛି ତା 2015 ରେ ଆପଣ ଟଙ୍କା ପାଇଲେନି ତା
in the barrel to Guru.
ଦେଖୁନ ସେଲ୍ କରିଛି ଲ୍ୟାଣ୍ଡଟା
Statement of
ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ କେବେ ପାଇଛି and most interesting my lord
is written on his plate.
No, what is it?
You would argue in charge, sir.
But it's a thing, I ballet see the statement of Sergeant Himram at page 18.
No, see, where does it say that I have withdrawn from back these two witnesses? You tell me that these notes which were withdrawn from Union Bank. How did you say? These two people are saying it's all right. But you only from the statement they brought it from Union Bank. Then I can relate that note to those two people. From where evidence.
ସେମାନେ କହୁଛନ୍ତି ଆଜ୍ଞା ବ୍ୟାଙ୍କରୁ ଆଣିଲୁ ୟୁନିୟନ ବ୍ୟାଙ୍କ କି ଆକ୍ସିସ ବ୍ୟାଙ୍କ କି ପଞ୍ଜାବ ବ୍ୟାଙ୍କ
So, so in the trial, but they will cross-examine that point.
No, madam.
They have the right to do that.
This question would have been specifically put there, but because if
Therefore the trial, sir, therefore the trial.
no, madam, if balance is by kindly see.
I think you can argue that those.
No, madam, kindly see. Huh?
How you will see.
Take it up, madam, next week. I'm sorry.
Next week?
Madam.
Okay.
And madam, one prayer I want to make.
But I think you should, you withdraw it and to argue,
I'll do so, madam.
like what I'll do is, I will give you liberty to do a specific application.
I'll take that liberty, madam, next week.
Yes.
Madam, with regards to item number 39 and 18, today, madam, is
18, 2 o'clock I have kept it.
madam, 18.
Tomorrow. Because what, I am going to allow that.
No, madam. 39 and 80.
18 only I am talking about. It is NGT order.
No, 80,
80, okay.
I will 3 p.m. Because, madam, I will not be available in the
Urgent call. At the request of Mr. Dar.
Have 80, madam, 2 other councils are there.
Please inform, you tell your junior to inform at least.
Madam, I have asked Mr. Debasis Panda. He is also there, Mr. Pambu, for 2 other accused.
And he will tell, he is waiting. You please tell, huh?
Madam.
Don't make them wait. Okay.
Your lordship adjourn it to next week.
Next week.
से 13 तारीख आसु 13
13, okay, 13.
हाँ, ठीक.
हाँ जो 4 नंबर 5 नंबर टा
Yes.
Item 6.
Item 6 kindly be taken some other day.
Why, madam, to argue? What is this case? At least you tell me.
A question of FIR, it's a forgery matter.
Hmm?
The allegations are that the petitioner has forged EC.
Okay.
For the issue, my lord, by giving for the issue, the EC, they have registered the cell date. Then, my lord, sub-registrar, while verifying the same, he came to know that registration has been done on the basis of that fact EC. Then he has lodged the affair.
Somebody sir, man. Investigation is
In progressment and is
madam, investigation is going on. Let it go on. Cognizance, therefore you come.
Yes.
I will give that liberty. If you are senior would have appeared, that liberty also I would not have given. Because you are appearing, so therefore I will give the liberty. I give the liberty after the investigation is completed, you can approach if the cause of action still. Okay, right on. Petitioner in this petition has challenged seeking quashing of the FIR. Jatni PS case number 259 of 2024, registered on 29/6/2024, corresponding to GI case number 470 of 2024. Mr. Janal and counsel for the petitioner state submits that the investigation is still in progress. Therefore, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to renew his prayer if cause of action still survives after the police concludes his investigation and files the report under section 173 CRP. Yes.
Item 7.
Yes. Yes, sir.
But it's a case of 138 of an act, I have challenged the order of cognizance. Now, my lord, your lordship can see page 11 is the cognizance order. Page 11.
Mr. Maharaja, changing side became very little mild. Yes.
Plus what it, page 11. Page 11 is the cognizance order, 138 of an act.
You are the accused.
Yes.
Yes.
Your lordship can see.
What is the check amount?
Check amount, my lord. I'll say, my lord, this is just a different 17 lakhs. 17 lakhs, 17.
Okay.
But I lordship can see. My checks have been missed. It has been misplaced. That is why I have filed an FIR before the police and it is registered. Special that it
Where is that FIR?
Yes, that is there, my lord. That is in page 20. You'll also may kindly see Annex 3, page 20.
Only diary entry.
Yes.
When this FIR was given?
Then I'm coming, my lord, to that. First, my lord, the stationary entry has been made. I have lost the FIR that my checks have been misplaced. Then, my lord, the complainant lost the FIR, my lord. You'll also may kindly see page 16, Annex 1.
Yes.
Page 16, Annex 1. But he filed a FIR under section, it has been registered on section 420, 422, 468. However, I have, with all respect to the law, I have got bail from this honorable court. I am released on bail. But I am released on bail on, you also can see the date I am saying that I released on bail
I'll issue notice, let us
on
see.
19/4/2024.
Yes, I'll let him come. Who
But
will
now,
write
the
this?
magistrate, what happened? Well, the complaint case, again, he filed a complaint case. FIR registered, no doubt about it, FIR registered. Then one complaint case also filed by the same complainant. Right? And cognizance taken 130 days ahead. 210 says, 210 of this.
I'll issue notice, I understood it.
Yes.
I issue notice and issue notice to opposite party number or to Mr. Private case, opposite party, sole opposite party, yeah. Retainable within 2 weeks. Requisite to be filed by tomorrow. In the meantime, the petitioner is given liberty to move application before the trial court seeking adjournment if the complaint case is taken up, owing to the fact that the matter is sub judice before this court.
And day after tomorrow, you can say file. Day after tomorrow.
Day after tomorrow.
Yes.
You move application there and bring him
Yes.
so that we will see. But 17 lakhs you pay.
17 lakhs.
How much? What? Check him
17
out.
lakhs. 17
How
lakhs.
much you owe?
No, he has taken a plea that I have taken 17 lakhs from him.
But what is the fact you tell me? Forget about it.
Totally different.
How much?
Totally different. 17 lakhs. The actual fact is that
How much
I
you?
have not taken a single pie from him.
How you have no relationship?
Something. I have, that is why I have allowed the affair. It has been stationary, it has been made.
Okay, let him come.
Yes. Adjournment application has been filed.
Yes, sir.
Yes.
Yes, yes.
Here the petitioner filed this application for passing of the proceeding minor initiated against him minor. In the meantime, matter was split up minor. Other three co-accused persons are acquitted in trial court minor.
You must be absconding.
Absconding, charged as absconder minor.
Yes.
But in the meantime, one of the co-accused who was in same footing minor approaches before this honorable court minor.
When is that
And the
order?
ordinary court that passed this order.
What does it say?
3307 of minor.
For the director of the entire court initiation over the matter of
Surrender and release of the same thing.
Not accepted the application and rejected man.
Huh?
Because he has approached first or second, that order was passed
Yes,
one case, and another case matter, that no order was passed. In accordance with the law, he can approach before the court.
Same order, man. Actually, same order.
They neither the ballot court.
Regular.
No, normally in there.
After acquittal of the court.
Accused might be. Those are the approved persons. They have approved before this honorable court. This petitioner is one, and another lordship is holding a order of another accused, and also another accused, and one accused. This order was passed, and another accused. My lord, this Sachika Minister passed an order that he has not entered in that application.
Not entered?
Not yet. Totally entertained the application, rejected, directed to surrender.
How many of you are there?
Man, there is.
And this is a case of murder. I also see the eyewitnesses are there. They have stated the direction.
They have not stated the position of yes, minor. I'm sorry, unless the eyewitness deposition minor.
How many witnesses total accused are?
Total is 15 minor.
15. Two of them have, three of them have.
It's abetted minor.
Okay, two of them are acquitted. And he is Pradeep Jena.
Pradeep Jena minor.
Pradeep Jena. Pradeep Jena got this order.
Got this order.
What about the other accused persons?
That is my lord, the CRLMC. The order is not with me. Late I verified that.
You, in your case, what is your name?
Ajay Kumar Jana.
Ajay Kumar Jana. Have you ever approached this court at any point in time?
This is my first application, my lord.
First application.
My lord.
What about the other accused person?
I don't have the particular.
You have all the instruction, don't worry. Because everything which is supporting you, you have instruction. The other thing you tell me. You tell me, I'll try to find out a way and give you.
Fix it
That's
to.
not the part for us.
No, it is not possible. It only says that he will surrender before the court and face the trial, and the court shall release him in bail.
And not religion on second.
Cooperate with the investigation and legally conclusion of trial appearing before the trial court and each on every day. So and so, क्या है?
This is the certified copy of the bail order in trial.
It's not in religion on. First hour, second. First hour.
Further, it is directed that in the event the petitioner is illegal bail.
My lord.
Who stops you? Who stops you? There are three. Do the same thing.
So I surrender.
Right now, petitioner is accused in FIR number so and so, so and so. After investigation, charge sheet has been filed on 28/10/2017, showing the present petitioner as an absconder. The petitioner was, you have been declared as a proclaimed offender?
No, man.
Naturally, you might have been declared. No.
No, man.
Yes. Absconder. Three accused persons, namely Somendra Ranjan Jena, Babula Vishwaranjan Jena, yes, Vishwaranjan Jena, Benzer Jena, face the trial. Face the trial. And insofar as the trial of the present accused and other absconding accused persons are concerned, the trial was splitted. Benzer Jana, while facing the trial, died on 7/12/2015. Hence, his case, the trial qua him was abated. Insofar as the other two accused persons who faced the trial, they have been acquitted by the trial court by the judgment dated 13/7/2016. 16 in Sessions trial case number 109 of 2014. Petitioner, by relying upon the said judgment, seeks quashing of the FIR qua him. The counsel for the petition further relies upon the order dated 19/9/2024, passed in criminal MC number 3307 of 2024. 24. One of the co-accused, Pradeep Jana, had approached this court, by the order dated 19. One of the co-accused, Pradeep Jana, who is similarly situated like the petitioner, has approached this court by filing the aforementioned criminal MC. The order dated 19/9/2024, this court passed the following order, para 6 and 7. The counsel for the petitioner submits that he, being similarly situated like the Pradeep Kumar Jana, is entitled to the same relief. Taking into consideration the facts in entirety and the order placed before this court, I am inclined to allow this petition, partially allow the petition, and subject.
Not there.
Huh?
Your file not inclined to pass the application, your lordship will observe.
No, partially inclined to allow the petition and give liberty to the petitioner to surrender before the trial court on or before 30th of November, so and so, and resort to the remedy available under law. It is also made clear that in the event the trial court enlarge the petitioner bail, the petitioner enlarge the petitioner's bail over and above the condition to be imposed by the trial court. the petitioner trial court, the petitioners shall also be bound by the court to appear before appear to face the trial on each and every day without bail. In the event the petitioner is found wanting for non-compliance of the condition to be imposed by the trial court, the concession of bail to be granted to the petitioner shall be withdrawn at the instance of the prosecution and the instance of application by the prosecution. With this observation, the petitioner is disposed of. Yes.
It is nice.
Let's pray for 1 week after for filing of additional documents.
What are you seeking here?
For passing of order of cognizance because the petitioner is a leaseholder.
Where is the cognizance order? Nobody the cognizance order, not the charge sheet, only a fire you have.
That's why additional document.
Why did you file it then? Thank you very much that you at least FIR you have enclosed. How these petitions are being numbered, I don't understand. You challenge the cognizance order is not filed. Forget about the charge sheet. Only the FIR is filed. And that FIR is also not feasible. How these petitions are numbered?
You're also saying that he is a leaseholder, nothing is there in the record.
And anything you file, it is numbered and listed before court. I'll allow but to pay 500 cost to the bar. Then counsel for the petitioner in this petitioner challenge the where is that order? Order date is also not there. Order date is also where is the order for following date?
It's there with
where is that date?
Date is
why? Just see the prayer.
17/8/2023.
See the prayer, read the prayer. After hearing the parties, the investigation of wide Janki PS case, number so and so, corresponding so and so, in the file of so and so, may kindly be quashed. Where is that order of cognizance? Where is that? Are you sure that you have challenged the cognizance order?
Yes, there it's
Here case
What are you filing?
cognizance खुलता मैं kindly request. Withdraw करें तो better application दियो better.
କିଛି ନାହିଁ ଏଇଟା ତ ଖାଲି order of cognizance file ହବ ଆଉ ଏ file ହବ କଣ
You have not filed anything. You have see your prayer, see your petition. No coordination, nothing. Adjourn it. Put it in January. Go and research on this. January. Okay. But file it. Why don't you do one thing? You withdraw it. Better you file a better one. Because once the matter is taken up, you are bound to, better you withdraw it with the liberty to file a better petition. With all particulars and all. Right. Then counsel for the petition seeks to withdraw the present petition with the liberty to file a better petition with all relevant annexures. With this liberty, petition is disposed of. You file it so that it will be listed immediately. Okay. Okay.
May I please your lordship, my lord? I am challenging the order letter 9724, my lord. Whereby Law and Court has passed this order, my lord.
Yes.
To adduce the witnesses named in the complaint petition, my lord. Though I don't want to examine them, my lord. I have already examined 2 witnesses and kind of order letter 30, page 38, 9724, my lord.
97?
2020.
What are you challenging? This order please the matter and direct the learned special judge to proceed with the matter without insisting the complainant to produce his witnesses. The same is causing abuse of procedural. What is this?
Yes, madam. I filed a protest petition, madam. Initially, I filed a FIR and that.
How can the court will insist someone to Mr. Jana?
My lord, your lordship.
The court is insisting someone kindly see the, my lord, that order, my lord.
Where is that?
That is my lord, test 38.
Hmm?
He has filed the protest petition with two witnesses, my lord.
Hmm?
And from outside, he has brought out two witnesses and they have been examined. But the names which have been mentioned in the complaint petition, my lord, they are not, the court is insisting to bring them.
Why could we insist?
Yes.
If we will not examine, the consequence will follow.
Your lordship, my
His protest petition will be dismissed. Why the court is interested that you examine this witness?
because he has stated, I will,
Maybe
in the first instance, he has stated that I will brought that witnesses.
whatever he doesn't want to do it, can the court force?
He can dismiss it. But lordship, you can see in 2000.
Where is the order?
Page 38, my lord.
The complaint is present in the Hazira and then counsel for the complaint files memo that the complaint doesn't reduce further evidence and perusal of the record. It reveals that on says that the order has been passed directing the complainant to produce the list of witnesses, namely so and so, so and so, so and so. Named two witnesses are required to be examined and so and so. Hence the complainant. What is this? What
What are the previous order, your lordship?
no, maybe he might have said today he says that I'll not edit. You close the evidence.
The property case is not made out. Your lordship, I know that.
No.
Second of
Petition is agreed by the order dated 9/7/2024 passed by the.
And I'm relying upon a decision, my lord.
No, don't rely. I'll allow it. Passed by the learned sessions as Nuapada in
My lord, the one
essay number
essay number
14 of 2023. 23. The learned court below in the impugn order has inter alia directed the petitioner, who is the informant of the complainant in the protest petition, to record the evidence of two witnesses. The petitioner inter alia contended that he is not interested to lead further evidence. However, the trial court has been insisting to adduce the evidence of two witnesses already named by the petitioner.
No, he is not named in the.
Two witnesses. Relevant would be to reproduce the impugn order. 9/7/2024 order at page 38. So, I peruse the documents, please, in this petition and analyze the impugn order. I am of the considered view that court considered view that the court below is I'm unable to agree with the reasoning given by the court below, insisting the complainant to adduce evidence of any witness. It is the prerogative of the complainant, informant, to choose the witnesses, and the choice should be left to the complainant regarding the nature of evidence he or she want to adduce in support of his complaint case. Okay, complaint case. Therefore, the impugn order is liable to be put aside. Accordingly, the impugn order is set aside.
And the court may proceed with an agreement.
The trial court is at liberty to proceed in accordance with the law on the basis of the evidence brought on record by the complainant.
Obliged me.
Yes.
11. Here I have prayed for questioning of criminal proceeding. On the ground that the complainant was the wife,
Complainant?
Informant was the wife. 498. The FIR was lodged under 498 and other offenses.
Yes. Where is you have not included the complainant?
Here, my lord. Thereafter, there was an amicable settlement. The informant went to her in-laws. Now, after she went to her in-laws, she committed suicide, for which another FIR was registered and criminal proceeding was initiated under section 304B, 302, and 498, and these allegations form part of the subsequent criminal trial. So my prayer is before this honorable court that the first criminal trial or the criminal proceeding which was instituted at the behest of the deceased wife will not sustain on the ground that it might affect the principles of double jeopardy.
490 is a continuing offense.
Although, my lord, it is a continuing offense, but there is a second FIR, and in that second FIR and or criminal proceeding, 498 is also I have been
This is not a
charged.
complaint, here case.
See, now what is this stage? This is the investigation stage.
My lord, in charge sheet has already been
Filed. Okay. Charge sheet is filed. You tell all these things before the trial court. The trial court may not frame the charge against you.
No, my lord, at best, it is the due.
No, it's a continuing offense. And the 306, which is subsequently has happened, is a culmination of the continuous torture. So therefore, as he rightly says that it is a continuing offense.
Yes, my lord, but here the validity of first criminal proceeding which is pending. Now, ultimately, it will result in the acquittal of the present.
Why?
Because, my lord, upon the death of the informant, it will stand.
Other witnesses may be there.
This is not a
Torture element can be proved by the other witnesses also.
This is not
Not necessary that the person who has been tortured, who has died eventually,
My lord.
it's a necessary witness. The other witnesses may prove the case. If there's a headache of prosecution, Mr. Jana will do it. Why do you worry? Otherwise, you will be acquitted.
Because, my lord, ultimately, the second trial which is continuing, it has substantially progressed, my lord. Now, after this, even, my lord, even for the sake of argument, I have been convicted. Now, when I'm in jail custody, I will again convicted for conviction.
What you should do is, therefore, ideally, what you should do is, you move an application for tagging both the trial together and proceed. That is the remedy for you. Not that the same witnesses, everybody is same. Instance is also more or less the same. So you move an application under right rulings of the court for tagging both the thing and trial should proceed together. That's the idea.
No, with that observation, my lord may dispose.
I will not give observation. I will just give you liberty to proceed in accordance with the law because I can't advise on the.
But, my lord, it is the power.
I just because you are a young boy, then therefore I'm just suggesting you to do that.
Yes, 498 is always.
And further suggestion, Mr. Jana will give. Withdraw it, take the liberty, and whatever remedy available to you under law, you proceed with that. That liberty is
my lord,
open.
I will appreciate my lord with regard to the double jeopardy aspect.
No, it's
because the validity of second FIR.
It's not a.
498 has also been, I have been charged in the subsequent FIR also.
And if you bring the double jeopardy thing, then it is, it can be tasted only after the penalty is imposed. Not
Continue the proceeding, my lord.
No, it can't be.
Because my lord is indicating to section 300 of the CRPC, which is with regard to trial. However, with same set of facts, two criminal proceeding, cannot
say it's not same. One before the suicide has taken place, torture, and because of the torture, the culmination of the torture is the suicide. There are two FIR. And you can argue that insofar as the second FIR is concerned, 498 is not made out because in 498 torture, I have been facing in the another FIR. So therefore, don't frame charge. The court will not frame charge on the 306 movie. You never know what will happen. If the charges are framed in the first FIR, if the charges is framed in 498A, in the second FIR in 306, then you will know the remedy. You can ask the trial court to tag both the and proceed. So it will be one FIR.
My lord,
you will be, even if you are convicted, the substantive sentence will run concurrently. Then there will be no case of double jeopardy, as you say. So you can erase the double jeopardy by resorting to right provisions of law. Right on. Then counsel for the petitioner seeks to withdraw this petition to avail all the remedy provided under the criminal procedure code at the before the trial court at appropriate stage.
My lord, liberty will be granted if necessary to approach this court of.
Liberty is granted with this liberty, the petition is discharged. Liberty is also granted to the petitioner to approach this court if the cause of action arose at any stage. Okay. Well, now you exercise that way. You first argue on charge, depending upon charge, move the application. Yes.
My lord, on behalf of Mr. A. Patnaik, I am permitted to praise, my lord.
Withdraw.
Permitted to praise the matter, my lord.
Yes.
The lordship may kindly directed first of second parry the same day disposal, my lord. In the meantime, charge sheet already submitted and the present petitioner challenging the cognizance order. But I am pray before your lordship only first of second parry. Same day disposal.
What is the parameter for 482 to test the cognizance order? What is this first hour, second hour? I don't know.
Hey, they have filed, but I am not pressing that.
Normally, I this.
My lord.
When that order? I've seen that order. Well, see the cognizance order is correct or not? That is simple.
I am not pressing. I pray before your lordship.
Where is that order? Parity order with yours? Where is that order? Show me that order at least. Do you have that order with you? Do you have that order with you?
My lord.
No, you say give me that order.
I have taken abarment, but again. Next week I will make.
Give me the number, I'll take it out. What is it? Unnecessary way. I'll pass the same order.
My lord.
You said that one of the coaches has approved this code and got.
Pass over.
Where is that? That's what I'm saying. Show me that order.
My lord. Pass over.
I generally don't incline, but still, if you say one of the coaches has got it, then I'll give it. Get it, I'll just pass over. Yes.
Lordship, petitioner being the husband challenging the ex parte order in the 125 proceeding dated 18/3/2024. My lord, that is the entire order sheet I have annexed at Annexure 5.
125.
My lord.
You are the
Husband.
What is the award?
There is no award, my lord. I have not taken part in that proceeding. Setting me ex parte, the matter has been set for judgment. No award has been passed.
You want to participate?
I want to participate, my lord. I have filed an Section 9 application before the family court, and that was allowed yesterday. And
Jana. Madam, yes.
And in this
125 proceeding. See, the practical problem is, I'll tell you. No, you don't have, this is a private case, you just concentrate, I'm just, no, copy is not required, I'm just asking you one thing. It is a 125 proceeding, initiated by the wife. The husband was not given opportunity, proceeded ex parte. Now matter is fixed for final disposal. She wants that she should be given opportunity, husband should be given opportunity to participate in 125.
126(2) is the.
If the ex parte award is taken, how will you execute it? She should not appear at the
At the end, I am the paying party. I'll pay. Being the husband, I'll pay. And
even if she get an ex parte order, and for execution, she will run around.
Exactly.
She should be there in the proceeding itself.
126(2) is the only remedy, my lord. Petitioner husband filed an application before the court below on 21/10/2024. 126(2) application that was not taken into consideration. My lord,
what is the stage when the final order is to pass?
Only that application has been passed. No order has been taken. Granted.
Show me the order.
Lord, I have only the last order. 20.
What are you doing? What is this?
I'm working in a software company.
Software company. Your wife is also working or?
No, she is not working.
They're not paying anything.
No. A small chance will be given for participating in that proceeding, so that whatever amount of maintenance was granted.
There is a child also.
And one Section 9 application has been allowed in favor of me. and I'll execute that. I am ready to take my wife and family. I'm ready to start my family. But she is residing at her own parents' house at her own will. But will it give?
What is the age of the child?
It's very small, my lord. I don't have the knowledge about that.
Where is that order? You just
Page number 31, order dated 8/3/2024.
18-3 to
8/3/2024, my lord.
18-3, no?
18/3.
18-3.
Page 31.
31. Yes,
My lord.
18-3. The case is put up today. The counsel for the petitioner is in the court today in the final Hajaras. Also, we can report that he refused to accept the notice and the same will return to the court. Hence, this is held to be sufficient. This case is set ex parte. Also, this ex parte order you want to set?
My lord. No interim has been granted.
The deposit something.
Something deposit and participate in the.
Nothing granted. How much amount?
You have a child. You are working. Your wife forget about the technicality. Deposit some money. 50,000 deposit and satisfied.
50,000, my lord, is very high amount.
What? The software engineer, what are you talking? You are giving to your wife and children. You are not giving to the charity. Deposit. You actually, when are you separated?
Separated since
How many years?
marriage is of 2022 and the separation is of 2024. From 8.
She is left with, nothing. Okay, 50,000 rupees.
Very high.
But that will not prejudice, that will not prejudice your case.
Whatever amount will of maintenance will granted in that one time.
I'm not maintenance. You do whatever. To begin with, you just deposit 50,000 rupees. I'll set aside it, and the deposit of 50,000 rupees will not prejudicial to your right to contest. Simple. Deposit. You are giving to your daughter or son, whatever.
30,000.
Okay, 30,000. Let's pay. Petition is agreed by the order dated 18/3/2024, whereby she has been set ex parte in a proceeding initiated by his husband, as his wife and children, wife and child. Only wife. His wife. Under section 125 of CRPC. What is the age of the child? 1 year.
Nothing has been mentioned in the 125, my lord. The only wife is filed the.
And what do you have the child? Huh? No, okay. I'll not write that.
My lord, no.
He has been set.
See, but he will go.
He has been set.
Nine of the.
9 to the move.
His wife, yes.
CRPC.
CRPC. The counsel for the petitioner submits that the 125 proceeding was has been initiated by the opposite party in MC number 4 of 2024 on 8/2/2024. The notice was not served on me.
Notice was served upon me and
They accept qualities. Notice ta jai
I am not staying at my village. I'm staying at my workplace.
Notice was sent to the petitioner. However, he has not been staying in the address given. Therefore, he could not be present in the court, which led to the impugn order. I have perused the impugn order and the explanation offered by the petitioner in the petition for its non-appearance before the court below. Without admitting to the merits of case, I am of the view that the impugn order is liable to be set aside, subject to petitioner depositing 30,000 rupees to show her bona fide. The deposit of 30,000 rupees shall not the petitioner, the opposite party shall not derive any equitable or prejudicial right in her favor because of the made persons to this direction. And this deposit is only for showing the bona fide for the husband, petitioner husband towards towards his wife, towards subject to depositing of 30,000 rupees. The order dated 18/3/2024 passed by the JMFC MTL in MC number 4 of 2024 is satisfied. Petitioner is directed to appear before the court on or before 15th of so 15th of November so and refer to the
File an application 126(2) for setting aside that may be.
sort of the remedy available to him under law. You appear on or before 15th and do whatever.
Yes, number 4.
Move the money, 30,000.
126 petition is pending, madam.
Whatever is pending.
That may be considered.
Liberally considered रही जगह 30,000 दे देंगे. बेटा से expert हो satisfied पे petition दी थी.
Except that petition is pending before.
126. What is that application?
That application I have not copied. Don't have the.
Let come support the petitioner for the service that his application under section 126 CRPC is pending.
Down 21.
Pending the same shall also be considered once he appears.
Application told them
and appears before the court. Yes.
That would not.
May I please, Lordship?
Yes, sir.
Lordship, the order of cognizance is under challenge before this honorable court, primarily on 3 grounds.
Yes.
First is, my lords, the cognizance has been taken of the offence for which there is a clear bar under the CRPC. First. Second thing is, Lordship.
What is the offence?
Lordship, 188 is there. So, my lords, complaint case has to be filed as per section 195.
Yes.
But FIR has been lodged. Second, my lords, from their perusal of the charge sheet, no offence under section 269 IPC and 270 is made out in this case. And third, my lords, investigation has been done by a police officer who is not authorized to investigate the matter as per the special statute, that is Epidemic Diseases Act.
Yes.
Now, my lords, I will just briefly place the facts. What has happened in this case? The petitioner is a lady advocate, regular practitioner of Jharsuguda Bar. Now, way back in the year 2020, when my lords COVID was there, on 12th August 2020, one COVID patient was detected in her locality. So, my lords, that area was declared as containment zone. Now, after my lords, verification of that patient and contact tracing, the officials took swab samples from the petitioner on 14th August. Well, it's 12th August, a containment zone declared. List of dates is there.
Who is the complainant?
Well, its complainant is the executive magistrate. Not complainant, the informant. FIR has been lodged in this case.
I'll just issue notice to us.
Actually, the state is the, my lords, will be the.
Remove application. What is the stage?
Well, its cognizance has been taken.
Only cognizance is taken. Okay, issue notice. Like accept notice. What are the offences you said?
188, 269, 270, read with section 3 of the Epidemic Disease Act.
Petitioner number 1 is a lawyer.
Lawyer. And 2 is my lord's husband. Husband of petitioner number 1.
So, this, the pandemic time, everybody was under stress. Something might have happened. And she is a lawyer. Unnecessary what is this? To try to find out some way of to. I'll stay the proceeding. Just see, in the pandemic time, everybody was under stress. Something might have happened.
Anku positive report asila. What she did immediately, she also, my lords, Apollo nije out swab dele. Tar result is negative. I have annexed the report. So, my lords, in this time,
that time everything happened. Everybody was under stress. You call it, I am staying in the proceeding. You should notice, stay the proceeding and check it up. You find out some way if it can be quashed, we will quash it. After all, she is a lawyer. Yes, you're right. I'll just.
Which was captured by the accused persons, and the mercenaries has been ransacked and sold on the 17th of April 17.
Yes.
Then the petitioner approached the police, but the FIR was not registered, so he has to take the course of section 156/3. Then the FIR was registered, and the police filed final report as mistake of fact. The petitioner filed the protest petition, and cognizance has been taken on 24/7/2023. And on 11/3/2024, the 205 petition of the main accused, Deepak Patnaik, was rejected. All the accused persons are appealing bail. They have appealed bail, but the main accused person is not appearing and not getting the bail. So my humble submission is that Worship may kindly give a direction to dispose of the case in a time-bound manner.
Then now in the court stage, how many witnesses are there? I don't know.
He is not cooperating with the court, Lord.
So then the court has the option to issue right process.
I can't control here by court. Even the envelope was not issued after 11/31/24. Lord. I mean, that's have been not appeared.
And this is very, very nascent stage, you know. It is when the cognizance was taken.
Cognizance has been taken on 24/7/2023.
23. You move appropriate application for the trial court for the issuance of process. I can't control the trial court proceeding here. At least you are the informant. And the people are on bail. The accused is not appearing because the trial court has to issue process. For that,
trial court has not issued NW. That's
no. Where is the proceeding? Show me the proceeding.
Annex of High Court
knows what to do, what not to do.
Yes, my lord.
Show me the proceeding. What happened in the last few?
I have the copy of order sheet.
Where is that?
In Annex of 5, Lord.
Yes.
Annex 5 series.
Yes. Who is that accused is not appearing?
Deepak Patnaik.
Deepak Patnaik, first one, huh?
First one.
Yes.
You kindly come to page 69. 24
I'm there.
24/7/2023.
Advocate for a complaint is present.
This cognizance has been
Cognizance 24/7/2023.
Yes, my lord. Kindly come to page 71, my lord.
Yes.
Order date 11/31/24. His application for 205 was rejected. Thank you.
Yes. They are appealing. All of them. Deepak Patnaik are also appealing.
No, he's not appealing.
Yes, 4/12/2023. Just see.
Sorry,
Case record is put up today for appearance. Sri so and so and his associate. File power of power for the accused so and so Deepak is also there. Some accused, some lawyer is appearing for them. And moved an application 205 application.
that was rejected, my lord. Because he previously was.
What is the problem?
He's
Not only 24, his application under 205 is rejected.
No, because, my lord, he has also filed an CLMC application to quash the order dated 11/2024. That's the problem, my lord.
Can I pass an injunction? Whatever right he.
I'm saying that this case is also posted today.
Where is that?
It's in 32 or 33 item.
32. Take up the matter with 32. Item to matter 32. Yes, see 32. Along with 32. Yes. 16.
Mr. Lordship, the item 16 permitted to withdraw with the liberty to place after the formation of charge, Your Lordship.
Yes. Liberty. Liberty to approach the court at the appropriate stage. Yes.
17.
Obliged, Your Lordship.
Here, petitioner says for trusting of the entire proceeding in respect of Chandrapur case number 106 of 2022. On the ground that no incident occurred within the jurisdiction of Chandrapur. And the allegations are like
Yes.
My lord, your lordship may kindly see.
What is the stage?
Yes, my lord, it has not been filed.
Filed.
No.
Investigation is going on.
That's it.
Okay.
Investigation is going on. The police may say that. Police may send it to the right jurisdiction for investigation.
I will, my lord,
I will just simply say that whatever points you have raised in this, you apprise that to the IO. IO should deal with that in accordance with law. Simple.
there is no provision, my lord, we have appealed. 41 notice was given, appealed before the police, my lord.
So there is no jurisdiction, no jurisdiction. Let the charge sheet be filed. It may so happen that they may not file the charge sheet also. You don't never know. It is premature. I don't. The petitioner petition is seeking quashing of the entire proceeding arising out of the Kendra Sadar PS case number 106 of 2022, corresponding to GR case number 497 of 2022. 2022 on various grounds, including the ground of territorial jurisdiction, lack of territorial jurisdiction. The investigation in the present case is still going on, and at the nascent stage, I am not inclined to interfere in this matter. Our liberty is granted to the petitioner to appraise all the issues to the IO of the present case, and the IO is directed to deal with the issues in accordance with the law. With this observation, the petition is disposed of. Yes.
Pardon me, it is with item 33.
33, 33, okay. Which one? 17? 19, okay. List it after 2 weeks along with law. List it after 2 weeks. Yes.
20.
May I please? I am the petitioner in this case. That on basic information, the case has been instituted against the present petitioner in the connection with Fatehgarh PS case number 178/19, arising GR number 221/9, corresponding ST case number 101/2020. At that time, examination PW1, PW2, PW3, and PW6/15. Advocate appearing for the present petitioner could not able to this question. Kindly recall this picture.
Sorry. You moved an application under 317, which is rejected.
Yes. Yes.
Rejected for that particular day. What happened to the next date of hearing? What happened? 39/2023.
Yes, under section 317 CRPC already rejected. Kindly
Rejected for that day. What happened to the next day? Next day, have you appeared?
disappear.
No, 317 is written. Only 3 and 11 maybe. The accused namely so and so is absent and represented under section so and so. The penalty petition under 3 so and so. It appears that the present accused person filed a petition with a prayer to recall the witnesses so and so for their cross examination. The APB objected the petition, saying that the same sort petition is already also in peril of the record further appears that on the same place after the accused of Kumar Vetri was rejected by this court and he remained silent and did not approach our forum and accused he came to this court on the same petition and is targeted case of Hon'Ble High Court of Orissa. Also, it is found that the presenting person was present at the time of loading of the opening the PW was the intention of the accused. It is not a yes. It is an application, not 307. 307 you have moved, no problem.
Yes.
That was allowed. You appear to have moved an application under 311 also. for recalling of the witnesses. But the same prayer was made by one of the co-accused person, and which has been rejected.
Yes, ma'am.
And he has not challenged it. And this is a case targeted by this court.
Yes, yes,
So
ma'am.
therefore, the trial court has rightly rejected. What interference is called for?
Whether of the matter the defense witness, accused statement is for the date of accused statement, he has filed the petition.
No. Right. Petition is agreed by the order dated 9/9/2024, whereby his application under section 311 CRPC for recalling of PW 1, 2, 3, 4, 1, 2, 3, 6, and 15 have been rejected. The trial court, while rejecting the prayer of the petitioner, has inter alia stated as under para 3 of the order at page 30. Okay? Page 30, para 3 of the page 30. But para 2 and 3. I find no reason to disagree with the impugn order. Because one of the co-accused person had made the same prayer earlier, which has already been rejected by the trial court, and the said order has attained finality. Now the same prayer is being repeated by the present accused person, and it is also pertinent to mention that this court, by a separate order, has already targeted the trial to be concluded with a limited time frame. In that view of the matter, the prayer of the petitioner made under section 311 CRPC at a belated stage of trial is an ploy to further prolong the trial. Hence, there is no merit in the petition, accordingly dismissed. Yes.
It is not also mentioned the part of
Which there is nothing except this. He has not filed anything.
Published.
Yes.
This is an application for quashing of the FIR.
Yes.
But I find that there is not a fit case for quashing of the FIR. But all the same, I may pray that on surrendering he may be relieved on bail.
No. What are the offences?
Offences allegation is 376 or 376.
Then bail application has to move. Like I can't in a quashing petition. Have you approached the court already?
No.
You approached the court. I'll just simply say that you will surrender till 30th of November, and no court action till then. You should to be remedied.
May I say that in case of rejection, I can move the
You do what? It's basically basically I'm giving interim protection to you.
No.
Meanwhile, you do it whatever.
Further, I pray that the first hour.
See, I should not have entertained this petition because you have fairly submitted that you don't want to press. So I'm giving this delivered. Right on. Petitioner has challenged. Petitioner seeking quashing of the FIR Chandrapur. PS case number 74 of 2024 under section 68 bracket C oblique 351 bracket 3 of BNS 2023. The investigation in the present case is still going on. At the nascent stage, the petitioner has approached this court for seeking quashing of the FIR. Therefore, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to surrender. Where will you surrender? Where it is pending. Surrender.
Before the.
However, it is left open to the petitioner to. If I make any observation, then your 41 notice will also be dispensed with. Unnecessary police will harass you. Why are you doing this? Had it been pending somewhere, I would have said that go and appear before.
Since FIR has been registered, it must be pending before the magistrate. There is no doubt about it. That is JMFC.
The investigation is going on. I can't ask you to go and surrender before some court.
No, no.
You have to cooperate with the investigation, IO. If I say something, you will appear before IO. The IO will, see, he has a right to, he often to give the notice also under 41.
Immediately you will forward me.
It is creating problem for,
You will forward me. Immediately. The moment I approve,
I don't know what can I do. You have asked for passing of the file. It's very difficult to make an observation.
government approve.
What kind of observation I can make? You tell me. I can only say that you can resort to the remedy available under law. That's all. Beyond that, I can't perhaps do anything. Had it been a bail application, I would have allowed or something. I would.
And on surrendering, magistrate may consider my application.
Where will you surrender?
Before
We don't know if the charge sheet will be filed or not. Surrender before the IO. Where will you surrender?
before the JMFC,
Why?
because that case is pending.
Why if the police after investigation may file a closure report? How do you know? How do you know? Why should I tell that you should go? You don't know whether you have committed the crime or not. Investigation is still going on.
Yes.
It may so happen that you might not have committed the crime. Why should I ask you to surrender before any court? Try to appreciate what
My anxiety.
suppose tomorrow the police will find that no case is made out against you. You have not committed the offence at all.
Right.
And before the commission of offence, the High Court is asking you to surrender before something.
But my anxiety is that he is a government servant.
You may have anxiety, but what to do, you tell me.
He will be immediately forwarded to the court. I take him to
You suggest me out of your vast experience, you suggest me what can I do for you? But better you apply for anticipatory bail. You get the anticipatory bail, what is it? That is the better remedy. With the license is not impaired. However, liberty is granted to the petitioner to resort to the remedy available to him under law. With this liberty, the petition is disposed. Yes. 22.
42 may approach it. The application for question of the entire criminal proceeding under section 363 of IPC.
What is it says?
Case means that now the status of the case means that both the parties has compromised between the parties.
What is this case? Investigation is going on.
Investigation is going on. That is the case of law and action.
Whatever, if you are seeking quasi,
my prayer only then the notice will go to the information. Thereafter, I will find some other petition.
I didn't follow you. What you are trying to say? Have you settled the dispute? Have you settled the dispute?
Yes,
you bring there.
In short that Malaysia
Manual sound. You bring him. Just next week, you bring him. What are the offenses?
Offenses only 363 IPC Malaysia.
Who is the informant?
Informant is the father.
That is Anirudh.
Right, Anirudh.
So bring him if you can.
He's ready. He's ready to
Bring him. Simply at that. Okay.
simply notice is not required. Right.
Court can't wait for your settlement. If you are really settled, call him.
No.
I can't issue notice and ask him. He have a small matrimonial dispute and all. These are kidnapping cases.
It is sorted Malaysia.
Sir, 2 weeks.
Sorted.
Yes.
Matter was already set.
Investigation is going on from the police also.
Nice.
Make a statement that they will file the closure report.
Informant ready to
Maybe you can tell that my
tell me it's sorted.
charge sheet has not been filed. Investigation is going on. The same thing he can go and tell the police. That's wrongly I filed. My daughter has gone by her own violation. See, they will file a closure report. Why are you coming to the court at this stage?
He's ready to Malaysia.
You go and tell. I'm mentioning it. Tell the police. Police may close the case.
Yes.
You need not come to the High Court.
Yes, Malaysia.
Yes.
Always.
No, please.
Yes, sir.
Matter of compromise.
Compromise.
The offense 376 already married. And
Where are they?
so I told me that we will also fix to 30, 1-3 next week.
30. Okay.
1-3,
1-3.
13th of
Then they married.
Marriage, I will produce the marriage certificate and also present both the parties.
13.
Right.
Okay.
Problem.
24.
Yes. Yes.
It's a case manual for question of the first information report, which was registered under section 323, 34 IPC 376 to N.
Yes.
So, but 76 is concerned, my lord. The prosecutor who has lost the affair is admitted aged about 27 years. And the allegation is, my lord, after picked up acquaintance with him, with his petitioner, he continued relationship with him and assuring him to give a job. He has attended with him so many times in different hotels and also with consent, both of them had physical relationship with each other.
In the afternoon, she is already there. Troubling her. You had in her account. Now the case so many things. Now you have settled the bills and the girl is there. You will also not get it.
what I'm submitting was the component is operation.
I know.
The component is not the girl. The component is the this is that the girl.
Considering to the fact that in the absence of accused, I will cross it.
No, that's what I am submitting before the girl is not doesn't want to approve.
Has been happening. The accused has to be here. Call him at 2 o'clock. Call him at 2 o'clock. Hey, let him come. I do not have. Call him in BC because these people are high tech people. Must be working somewhere.
No, plus I'll ask him to be present before your lordship.
2 o'clock? At 2 o'clock.
Yes, at 2 o'clock.
Bring him. Tell the girl also. The girl may have some grievance. Who is the informant father? Call the girl also. The girl may have some grievance. You never know.
But she doesn't have any
Call the plus at 2 o'clock. Okay.
Yes.
Let me approve. Plus I have no issues
with that.
Yes.
26. Maybe.
Yes, sir.
So the present petitioner has been implicated in the case under section 64 2 and 49(3)(5) of the BNS and section 6 of the POSCO Act, and he has been taken to custody, ballot. And in the meantime, and the ballot will see the affair. So affair is to this extent that admitted relationship is there, and on one occasion the present petitioner has forcibly kept the relation, and the mother of the informant, informant is victim, informant is also the victim, and she lost that it was known to my mother. My mother is also a party to it, but that means she also ready for the marriage proposal which was offered by the petitioner. But thereafter, I have lost the affair. Now, good sense people with the development is there. The girl is also ready for the particular purpose. She has also visited the jail on 3 to 4 occasions. The victim, I mean to say, and the mother against whom she has also made an allegation. Some disturbance was there.
What is the stage?
Affair stage. Affair stage.
Okay, you won't tell the police will file closure report. Because this development, I'll take cognizance of the affidavit which you have filed and all the affidavit and everything. You won't tell the police will take whatever.
A copy of the affidavit is not served to me.
A part of the
No, that is another document which is filed in my
Annex 2.
Is it another document?
It is today also file.
Whatever you
Annex 2 is the different documents in my brief.
you are on rule.
No.
Absconding.
No, custody, my lord.
Custody. You are not doing
Two persons are there. The own mother of the victim, come informant, is also an accused.
Petitioner is an accused in FIR number so and so. Initiated at the instance of the opposite party number 2.
My lord.
Opposite party number 2 for alleged offences under section 8. Okay. The investigation in the present case is still going on. The petitioner is in custody. At this stage, the petitioner appears to have settled the dispute with the informant. and an affidavit has been filed.
Today also they have filed the practice of
Affidavit has been filed before additional sessions judge come special judges under POCSO.
on the day of
Where is it?
at the time of constitution of bail.
At Cuttack. At Cuttack.
On the date of constitution of bail.
At Cuttack. Even an affidavit dated 7/11/2024 has been filed before this court inter alia stating as under para 3, 4 and 5. 3, 4 and 5. The parties are present in the court being represented by their respective counsels. I have perused the document placed before me. Since the investigation is still going on, the charge sheet has not yet been filed. It would be expedient if all these materials are placed before the investigating officer, who shall take into consideration the same, verify the facts, and deal with the same in accordance with.
If required 164 statement because for a minor.
I will not say what. Why should I can direct the IO to do what in and deal with in accordance with the law. Since the matter is at nascent stage, I am at this stage I am not inclined. However, the liberty as mentioned above has been granted to the petitioner. With this observation, petition disposal. You will file a closure report for us.
And Madam may also say based on this development, the I will proceed accordingly.
That's what I said. That's what I said.
Madam indicated that settle or anything.
Everything I will reproduce the affidavit. The contents of affidavit also reproduced.
May all such exercise because he's in custody. All such exercise will be made within a particular time frame, 2 weeks or 3 weeks.
The problem is I can't give direction to the police.
No, Madam, I am not saying for any interference.
Since the petitioner is in, I have written that since petitioner is in custody, it is expected that the IO of the case would act upon the direction as expeditiously.
My one more submission also. So for date of birth is concerned, there is some error in.
I will not say
that. Minor error. So as per the date of birth is.
That is there.
I will not say.
Yes, sir. I
will not say.
Yes.
27.
27 is
Malad, informant OP number 2 is the mother and the petitioner is the son. There was a dispute. 294/506 is the only offense.
matter has been settled between the parties, Malad, and both are present.
What is the offense? 294?
506.
What are the allegation?
Due to some dispute, the petitioner went to the mother and the OP number 2 is the stepmother. There was a land dispute. Accordingly, he was threatened. That was the allegation. Except
the petitioner.
Malad.
Okay.
Both are present.
Yes, check it up. Ask the opposite party number 2.
That's it.
Just ask her. Whether many time under influence,
निज नेम हस्बैंड नेम ठीक ठाक कहउछन त कोलिन समाधान हे गेछि बोले
समाधान हे गेछि हां सर की आपनरो कोन हितरा झगड़ा
पार्टी दिन रे गेला से पुओ दीपोर मु आपु से भाई आगरे सेंड कर देथि बोली ये ठीक से
एक केस ता खत्म कर दो हां कला परे पुनी हैरान कले
नहीं
पुनी करे केस
नहीं
administration of opposite party number 2, FIR number so came to raise against the petitioner. Petitioner is the stepson of opposite party number 2. The allegation against the petitioner is so. The petitioner and as well as the opposite party number 2 are present in the court, being represented by their respective counsel and those who are identified and filed self-registered copies. Have you filed affidavit?
My
Malad, I have already.
I am putting option number 2, my lord.
When is that? Yes.
My lord.
When the investigation is over, charge sheet
Submitted, cognizance has been taken.
when investigation in the present case has already been completed and charge sheet has been filed on 21/8/2023. Subsequent thereto, the cognizance of offences punishable under section 294/506 IPC has been taken against the petitioner. At this stage, the petitioner and the party number 2 have settled this dispute. The petitioner, the opposite party number 2 has filed an affidavit dated 24/9/2024 inter alia stating as under nothing. Stated nothing. Inter alia stating that the petitioner being his son being a son has committed the crime out of in a fit of race, and subsequent thereto they have settled their dispute and they are living peacefully. Hence, he doesn't. She wants to put a quietus to the entire dispute. On query from the court, opposite party number 2 who is present the court has also reiterated her stand and joins with the petitioner for quashing, praying for quashing of the proceeding. Regard being head to the facts of the case and submission at the bar, the case of the petition is covered by so and so. Was yes.
28.
My lord, the petitioner is a juvenile at the relevant point of time, 17 years, 6 months. The learned court below has taken cognizance of offence under section 465, 468, 471, 420.
Yes.
Allegation against the present petitioner is that while she was admitted in the city course, he was producing the fake certificate. And that was challenged. The petitioner is a juvenile. He should have faced the trial before the board. As because the case of
What is the proof of his juvenility?
the certificate, school certificate, as well as in the FIR, the running test 12, serial number 8. The name of the petitioner is reflects at serial number 8. 17 years, that was reflected.
Yes.
And during the course of investigation, somehow the police submitted the charge sheet against the present petitioner so as measure. Accordingly, cognizance was taken. Yes, sir.
Verified. Because at the time of offense, he was minor. It is an admitted fact. Issue notice, retainable on so and so. What is the stage?
In the meantime, charge has been framed.
The trial court proceeding qua the present petitioner is state. Okay. Verified. Because the minor than yes. Qua the petitioner is state. Yes.
29.
Yes.
29, your lordship.
Yes, sir.
This is an application against rejection of a discharge application. Now, my lord, the prosecution cases, the petitioner was the then sub-collector of Jajpur. Now, there were allegations by the villagers that there was illegal mining in that area. So, there was an investigation by the ADM as well as the sub-collector. He was the sub-collector, the ADM also, that there is illegal mining. The pillars which are to be, my lords, erected have not been properly erected. So, accordingly, it should revert back to the government and forest department should take, my lords, acquisition of this property for proper forestation. So, these were the reports. Now, the government doesn't act on the report.
Yes.
Lordship is aware under the OMMC rules, once the lease is coming to an end, the Tahsildar has to float a fresh tender. Otherwise, it will be government starts losing revenue.
Right.
These reports, it's all there on record. What I'm saying is not from thin air, my lords. It's there on record. The collector has also written to the said effect. Now, the government asks doesn't act upon our reports. So the Tahsildar is bound to hold a fresh auction. Fresh auction is held. I approve the, my lords, offset price. And thereafter, my lords, there is no allegation insofar as the conduct of that auction, my lords. Auction is held in accordance with law. The highest bidder gets the means, my lords. Now, suddenly the vigilance people turn up and say, because there was illegal mining, somehow you have connived and you have held a fresh auction. So, you are liable to be prosecuted.
That is the illegal mine when the prior auction would have
Prior to this auction, of which I have already given a report to the government. I, along with the ADM, we have already given reports to the government, my lords. The government doesn't act on the report, and if the government doesn't stay the auction, my lords, stops, my lords, outsourcing this error, then, my lords, the Tahsildar under the OMMC rules is bound to hold an auction.
Yes, Mr. Maran.
Let him file the charge sheet.
Charge sheet is already filed. I can have a copy.
The charge sheet টা দিন তো।
You just tell me the offense is the floating up for the fresh auction or mining? Mining, illegal mining before the auction.
Both. So far as their document is concerned, whatever document he has filed, where is it revealed from the order itself? Earlier, he has recommended the government to stop leasing. And again, he approved the knowing fully well that is illegal.
But he has given a report, the government has not acted upon that.
No, he should have sought for clarification. The ADM and the petition.
Then the procedure, there may be procedural.
Blatant in the case of the record. And your lordship kindly see the 34. Page 34. Page 34 of their bill.
Yes. Yes. You have to distinguish between irregularity and
I'm not on irregularity. I'm on illegality.
yes.
Illegalities, and it's a case of 120 rules there. And our case is that they connived with each other and the Sharia relief was granted. In respect of knowing clearly that the illegal mining is going on and they are excavating the mines beyond the leasehold area.
Where is that? 34.
The 34, well, you can, the suggestion he has given, he has conducted an inquiry. And 34, that is there, when illegal last para, your lordship, 33, last para.
Yes.
When illegal excavation was third line from bottom. When illegal excavation was recently extended to the habitation and the vegetation site, that lead to massive public resentment and immediate hype. The locational advantage of these two quarries have helped the unscrupulous quarry holder to carry out operation beyond the quarry area. The current auction holders have been asked to file show cause by 30th April 2011, and after receipt of show cause and examining the same, cancellation of the auction for remaining period may be contemplated as per OMC rule. And to check further damage to the area, after cancellation of the auction, the Sharia sources may be permanently closed and total area may be handed over to the forest department for plantation and land reclamation. If situation warrant, prohibited order 144 CRPC may be promulgated. Then I report, and then and RI news may be transferred from the circle as not a single enforcement. He has suggested everything. He has suggested to stop the Sharia, and even after 4 months, he is acting upon the recommendation of the Tahsildar.
No. You are supposed to, that is 28/4/2011. Okay? He gives report. What the government has done?
সেটা তো চার্জশিট দিলে কোন হয়েছে আমি জানি নি, কিন্তু our case,
the idea is he has given an exhaustive report making all suggestions. You don't act upon that. If you don't act upon that, it is obligatory on the part of the Tahsildar to go for a fresh auction. No, he has gone for fresh auction. So therefore, the previous conduct of the present accused is washed away after the report is given. Exhaustive report is given. If at all there is any crime he is committed, it is only pertaining to the floating up for the fresh auction. Let us understand whether fresh auction is modified act on his part or not. The charge earlier what he has done. Everything is reflected on his report.
So if the report is given, that means it's 123. The knowledge, it is within his knowledge. Why the report? Why have you not filed the FIR then? He has given report. And collector, even logic can see, collector has also, document, the collector has also recommended to the government accordingly. Where is that? On the basis of this report.
And one of the collector clarifies, if your lordship says page 44.
So what can he do, you tell me? He has given a report. He is that it is within his knowledge that illegal mining operation is going on. And it is within his, very much within his knowledge. And in the very, after 4 months, when the personalities he has pointed out that RI and Tahsildar all are connived. All are actually they are not their duties, and that's why illegal mining is going. He himself says that. He himself says that when you should have raised a case against other people. Don't make him as an accused and say that you. Again, acting up to the toss, report to the Tahsildar. Then you are grievance against the first press tender, then thereby pursuing the illegal mining. And the illegal mining operation, he only pointed out the illegal mining is going on. No, it is pointed out in the report. He may be the whistleblower. He might be the he is not the whistleblower because after his report, again has conducted an inquiry. Report is an exhaustive report.
It's page 44. The collector clarifies to the RDC. There was an internal inquiry. The collector clarifies to the RDC that such reports were given. As the government did not act upon such reports, the Tahsildar was bound to hold auction. That is at page 44.
Where is that word bound to hold?
No, it's page 44.
44. Let us come. Come there.
13 your lordships.
44. Read it.
My lords, that since no orders, this first orders they are given reports. Since no orders were received from higher quarters not to put the auction sources to auction, the present Tahsildar Dharmasala recommended public auction of these sources, and accordingly, Sub-Collector Jajpur has auctioned the sources for the period from September 2011 to 2012.
How many bidders came? Bidders. How many?
Public auction. Highest bidder has been given. It's
absolute. It's absolute. It needs to examine because there is something. Whatever the improved order says, the illegality is within his knowledge, and knowing fully well, he has acted upon on the basis of the Tahsildar's report recommendation. See, he knows it. Therefore, he is given a report. জানিলা পরে ইলিগালিটি জানিকি তারপরে জনে কাম করছে সেই লোক ইলিগালি যে করছে আসলে জানিলা পরে রিপোর্ট দিয়ালা রিপোর্ট দেলা পরে গভর্নমেন্ট কিছু অ্যাক্টিং কলেনি ন কলারু তহসিলদার অকশন করে হি ইজ দ্য সুপিরিয়র অথরিটি হি হ্যাজ অ্যাকসেপ্টেড ইট হি ক্যান নট হি শুড নট উই স্যাটিসফাই মি দেয়ার there is the case that is the you take satisfy me I issue notice okay issue pleasure দরকার নেই কারণ I will examine it
vigilance cases are not stayed, my lords. But if your lordships may observe, if I file an application,
that application thing.
Yes. Application. My lords, we are given a copy of the
entire copy.
Charge sheet. Oblige.
ସେ ନମ୍ବରଟା 400 ABLFL ନମ୍ବର 405 2022
give that order
or that is କାଢି ପାଇଲିନି
I passed it over only to see that
ଆଉ ଗୋଟେ ଡେଟ୍
no
405 2022 ABLFL
it is very easy for you to ask for an adjournment but at what cost you know that I am not able to adjust the board.
ତଳ ଗୋଟା
many people are mentioning in the morning and you are unnecessarily asking for adjournment. I passed it over to get that order. If I can get it, why can't you?
Sorry,
Thank you very much. You have not asked me to draft your petition also.
sorry, my lord.
Sometimes you will say that this is the relief I want, you please draft the petition and pass the order.
Sorry.
This also you are capable of saying. If he can take out, why can't he take out? 1 second job. I passed it over only to get this order. Yes.
My lord, in that case, my lord, the petition number 456. Last paragraph.
This is 456.
My lord.
456. 56. And you are for now?
The Okhya Pradhana, Ajay Kumar Pradhana, Akash Pradhana.
And the same people who had approached this court?
Again.
And the court has chosen to give the relief to 4, 5 and 6 and refused to give the same relief to you?
My lord,
Why you now file a separate petition?
my lord, the honorable court has been directed to surrender faster.
In so far as 4, 5 and 6 is concerned.
Like 4, 5 is allowed.
No. In so far as 4, 5 are concerned, considering the nature of accusation, negative will not record under them and that they are ladies and
Last paragraph.
accordingly. No, it is only 4, 5, 6 it was allowed.
4, 5, 6 are allowed. Accordingly, this court directed.
It is not there, my lord.
No, you are not entitled. Petitioner, all the 3 petitioners, along with the co-accused, Sanjulata Pradhan, Padmavati Pradhan, and Agri Elias Sumati Pradhan had approached this court by filing ABA appeal number 405 of 2022. The coordinate bench of this court, by order dated 1/2/2022, passed the following order. Passed the following order. Sorry. Passed the following. The result of the mentioned order reveals that insofar as the co-accused person, those who are the ladies member, the court was lenient and allowed their petition, allowed their anticipatory bail application in the aforementioned terms. However, insofar as the present petitions are concerned, the anticipatory bail application was rejected. Rejected.
Faster secondary. Rejected.
Where is fast or second hour? Where is that? No, there is no fast or second.
That is in view of the available material on record. By petitioner no 1, 2, 3, it is observed that in
where you are given this 405. There is nothing.
Expeditious.
And if you have that order, why are you not giving? You gave one number. That is 405.
It is settle modification for it.
Was turned out, was not allowed. The petitioner in the present petition has essayed the order dated 2/4/2022 passed by his DGM Badrak in GR case number 4 of 2022, whereby cognizance of offences punishable under section so and so is taken. So and so taken. The land counsel for the petitioner at the outset submits that he would not press this petition insofar as the challenge to the cognizance order is concerned, but he may be, the petitioners may be allowed to surrender before the court, and the bail application may be directed to be disposed of on the same day. I'm not inclined to a sheet to the prayer made by the petitioner in view of the order passed by the coordinate bench in the earlier occasion. However, liberty is granted to the petitioner to appear or surrender before the court below on or before he has filed many days on or before 30th November, so and so, and resort to the remedy available to them under law. Yes.
Same day.
No, same day. You see, you have concealed the fact. You don't file these things. So many cases you have filed. You try to be fair to the court. If you are fair to the court, you will get all relief. If you are unfair, you are bound to. No. Next item.
25.
Next item. I pass it over to assist, not to create the confusion and take the order. And don't be under that impression you can create confusion to this court. I'm very clear about it.
Dismiss it.
Whatever. You can't conceal half of the fact and half of this thing and try to get away with it. Don't be that under that impression. Please. Please, you try the somewhere else, not here. I'll impose cost if you speak a sentence. This is very unfair. Yes.
25.
Plus item 25, your lordship requested the petitioner to be present, but
yes,
he is present. He is there in VC, my lords. Abhishek on the video.
Yes, Abhishek is there. And
Jyotiranjan
is there. Yes.
65, my lords, compromise matter. That is have come.
Yes, so offense.
Offenses, my lords, so that the ESC Act and other minor offenses under the BNS.
Yeah?
Minor offenses punishment.
What are the allegations?
Allegation is set a grocery shop. There are only allegation of
what are the allegations of asking? You are reading now.
Allegation that the affair was lodged on 31/7/2024, alleging that while the husband of the informant and the nephew, namely opposite party 2 and 3, had been to a grocery shop of their village to purchase some grocery articles, at that time the accused persons abused them in field language and aspersing their caste name.
Where are they?
I am giving the other cards.
Where are they?
First 4 are the accused persons. And
see Rabindra Sahu.
Rabindra Sahu.
Rabindra Sahu.
Rabindra Sahu.
Rabindra. And Susanto. And
Sibo Pradhan. And the informant is Lily Bodhi. Is there. And other persons are the victim also.
Where are they?
There.
Vikas.
Amulya and Vikas. Amulya. She is Vikas.
A victim, call the victims and informant. Just ask. Ask them, please, Mr. Jana. Ask them. Injury, any injury? Any injury? What is the consideration they paid you? Informant 2.
Informant is 2.
At the instance of opposite party number 2, FIR number so came to be the petitioner. The opposite party number 3 and 4 are victim in the petition. All the opposite parties are present in the court, being represented by their respective counsel, and filed the self-registered copy of their Aadhaar card to establish their identity. The petitioner, all the petitioners are also present, being represented by their respective counsel. The allegation the parties have investigation is going on.
No, in this case, what happened at the time of filing of the application, investigation was going on. Now the charge sheet submitted.
When
I have in the affidavit, I have given the.
when the charge sheet is
Again, this is the
after
those are the
investigation,
summons issued to the petitioners.
when the charge sheet is issued,
Maybe recently.
file.
Okay, I filed crossing of inter-criminal proceeding. Charge sheet file. So the summons I have given the. And in the affidavit, I also mentioned that case number in the meantime, renumbered as TR case number 3 corresponding to.
After investigation, charge sheet has been filed in the present case. When the matter stood thus, the parties have settled a dispute. In the epidemic, what have you said? Nothing.
Paragraph 3
So poor drafting. What have you written? Read it.
During pendency of the above mentioned criminal proceeding, due to intervention of the village gentry and police officers, the disputes between.
This is how the criminal cases are passed. I felt it happy to file a reinstate a case. Today I am not happy, so therefore pass it. You have issued the judicial process, police investigated, who will bear the cost? At least have draft responsibly. What is this drafting? I don't understand.
Henceforth,
it is an insult to the court proceeding. I can't reproduce also. Parties have settled this. They filed joint affidavits before this court. Inter alia stating that on the intervention of the village entries and well-wishers, they have settled their dispute. The petitioners and opposite parties belongs to the same village. In order to maintain peace and tranquility in the area, they've decided to put a quietus to the entire dispute. Mrs. Nayak, Learned Counsel for the state, submits that since the allegations are minor in nature and parties have settled the dispute and filed the affidavit before this court, this court can give indulgence to the petitioner as the trial has not yet been commenced. Regarding head to the peculiarity of the facts of the present case and the fact that the parties have settled the dispute, the allegations are minor in nature. I feel it appropriate to give indulgence to the petitioner and quash the proceedings, particularly in view of the judgment of the Honorable Supreme Court in the matter and so on. Subjecting the petitioner to the rigors of the trial would definitely a futile exercise. Hence, the present petition is allowed and FIR number so and so and consequential proceeding arising therefrom. TR case will arising therefrom are quashed subject to the petitioners. How many petitioners are there? 4. Subject to the petitioner, each petitioner paying 2,000 rupees to the victim in the present case. Pay 2,000 rupees each to victim. There are four means victim. Informant is the lady. Informant. Give it to the lady. Informant. Give it to the lady. Yes.
69. We are also passing a criminal proceedings on the ground of compromise.
Yes. Same story.
Henceforth, I will file the affidavit mentioning also.
Now I will increase the cost. Obviously.
Today you will also
same affidavit. In that case, whatever you said, copy paste here also.
Henceforth,
both the cases are different case.
On the text to henceforth, the case of the year 2004, madam. in fact, the FIR
What are we-
under section 307.
307.
Under Annexure 1.
Show me the injury.
My lord, injury, my lord, injury reports, what happened here, my lord, 4 persons are injured. Out of 4, 2 in the meantime have been died. I have annexed their
Died because of the injury.
no matter. In the case of the year 2004, matter. And I have annexed their my lord, death certificates under annexure.
What are the injuries received by the other?
Injuries, my lord, I have annexed the injury reports. Starts with page 23.
You showed.
କହୁଛନ୍ତି
Just check it up. Yes, sir. Check it up. This is 307. Out of 4 injured witnesses, 2 witnesses, 2 injured have died. I don't know whether they've died because of the consequence of the injury sustained by them or not. We don't know.
It has certified copy.
No, you have verified. Because I would have done it because the poor quality of draft, I have simply examined it to verify.
Only reminder, appearance may be different.
Let them go. Let them go. Yes, 307. I may not cross also. I may not cross out.
Only one line. These are the certified copies.
Give it to him.
In which manner the IO manner wrote letters to the medical officer regarding the opinion of the injury matter. That it is reflected by that with reference to the subject matter, I am to request you that the final opinion of the injury may kindly be given for closure of the case as the case is year old. The patient is good condition after examining him and the IO manner examined them and wrote letter. But the final opinion not.
Let them assist. Let them assist. And see, this kind of serious cases, you should also at least do serious job. Not that copy paste some affidavit and file it and simply stand and pass it.
Fix the data so that.
After 2 weeks or 3 weeks, give it. He will verify. Yes. He will verify and tell me.
Yes, sir.
Yes. 30. Serial, no? Yes.
71.
We are very slow today.
71.
Settlement.
Settlement that 311 petition was rejected. And the victim has come along with the accused person. And they both are now married. They both married earlier. Also now they are staying together. Victim is staying in her in-laws house. And they are blessed with a child, my lord. So I have filed the 311 petition was rejected. That's why I have called the accused person and the victim. If court can ask personally to the victim that 71, my lord.
Your Lordship, I am appearing for the informant here.
71.
No, what have you challenged here?
A challenge, my lord. I have challenged the order that rejected 311 petition.
You should file a 482 petition for the purpose of quashing on the ground of settlement.
482 petition for quashing of the
that order.
Yes, my lord.
I'll set aside then. I'll set aside that order. That only the best I can do.
Yes, my lord. I only pray.
I'll set aside, you go and do.
Yes, my lord. Yes, my lord. That is sufficient.
I'll set aside 311. See, what happened is, it is a POMSO case. They've settled, they are married, whatever. She might have given an evidence against them. Therefore, the marriage.
Yes.
Thereafter, you 311, which is rejected. The fact remains that there is a child.
Yes, my lord.
What to do?
They both are present.
Allow your lordship by setting aside the improved lawyer lordship, director for further proceeding recall.
Recall then. See, you have to strike a balance.
Yes.
Right now. It is agreed by the order dated 25/11/2023, passed by the additional sessions as special judge POCSO Raigada, NPR case number 19 of 2019, whereby his application under section 311 CRPC for recalling which witness?
Witness
number?
Victim, my lord.
PW,
my lord here.
PW7, recall PW7
my lord.
has been rejected. Where have you said that you were married or whatever?
Yes, I have.
Where is the affidavit? Nothing.
Affidavit, I have given the deposition copy. In deposition copy.
Where have you said that you are married? There is a child. Where have you said?
That I have not stated, but I have stated in that is the.
Do you know what are you saying?
Yes, ma'am. My lord, but 2.53, my lord. That
where is the affidavit?
Affidavit, my lord. I have.
Very pathetic. You are, you people are trying to spoil the case of your clients. Or you are wrong. Somebody has to suffer. What to do? What to do? The affidavit, if you don't file, then how can I allow your application under 311?
I will file, my lord, affidavit.
Why will you call them that? See, that lady has come with a small child.
Yes, ma'am.
And sitting in the court since morning.
Yes.
And this is what you are doing. I'll impose cost to be recovered from you. Because if you have misconduct, this has happened. Do you realize that what must be going on in this thing? She's coming with a small child. She's a victim of a rape.
Yes.
What are you doing?
I apologize for my mistake.
Your apology will not help. See the agony of this lady.
Yes.
मजाक बना रखे. Put it tomorrow. Don't bring that girl here.
Yes.
First of all, you 311 petition. Why would you call this victim to here in the court? For what good reason?
That
Is the petition for settlement?
No, ma'am.
So why have you called her? You tell me. First of all, you should not have called that girl with a small child. Second, you don't file the affidavit. What is this? I don't understand you people. This system is there to help people, not to create trouble for them.
Yes.
If had it been a petition for settlement, I can understand. You can call the girl with the child. This is not a petition for settlement.
Not a petition.
You are calling him. You have not filed the affidavit. That girl is sitting outside with a small child. Put it tomorrow. Yes. File the affidavit now. See it's down.
Item 78.
70?
78. The 11 petition has been rejected, my lord.
Yes.
In the meantime, matter has been settled. I file an affidavit, my lord.
Yes. So 78. Where is the affidavit?
The file.
Yes.
When you cover by your my lord, regarding case, my lord.
They married or what?
My lord.
Have they married?
Valid, told valid, my lord.
In the affidavit, you have not said that.
Told my lord, you are told for the.
Where? Where have you said?
And I am appealing for the informant victim. And during 2021, the victim married to some other person. And
Some other person?
Yes.
Where are those things in the pleading? In the affidavit, you say that the police asked me to make depose something, I depose. Now I want to, whatever you say, I learned that the accused person is prepare an application before the honorable court to recall me and my so and so. See the affidavit, read the affidavit. Para 3 read, para 3 and 4. Read para 3. Best is they have not given it. If you read it, it is dangerous. Read it.
That being PW2 in the above case, and I have already
Read loudly.
That being PW2 in the above case, and I have already
No, PW1 read. PW1.
One.
Affidavit of Vijay Singh.
PW in the above case, and I have already deposed in the post as per instruction of the police.
However, after deposition, I came to learn about the actual fact, and at present, I have no grievance or allegations against the accused, Neeraj Pradhan.
You are making allegation with the police. You depose in the court because police asked you to depose. Now you came to know the real fact. If the High Court will accept it, the IO will be in trouble. What to do? You give them the copy.
Copy already sir.
The IO will be in serious trouble. Tomorrow somebody will say that you are influencing the witness to give wrong deposition. How can you make this allegation against someone? How can you make this allegation?
Well, 311 petition has been waiting matter in the meantime.
Police has asked you to go and depose in the court in this station. Because it is very safe for you to tell everything against the police. And these are the imputation against the police. So unless I verify, I can't do it. Give them, let them verify and tell.
Copy alert, sir, madam.
Verify and tell. You can't, sir, you can't write anything, everything in the High Court and get away with that.
I know my word, in the meantime, petition.
Once you give an affidavit, you should be responsible. In a 311 application, now you have settled yourself. Therefore, you make allegation against the police. Police asked me to give the position, and therefore I gave it. Now I realize that that was wrong. Because you settled somewhere else. You make allegation against the police. Tomorrow this affidavit may be used for any ulterior purpose by any of his colleague. And he lose the job. What is this?
Custody since my lord, let them release on bail, my lord. Last defense evidence,
whatever, such a irresponsible thing you have done, I can't help. Please. You make allegation against someone. Have you not made the allegation, you tell me honestly? You made the allegation on me. How can you make allegation against someone who is not taken party to this proceeding?
Yes, sir. Mistake.
That way a police officer. And going and affidavit against a police officer in the judicial proceeding about dangerous it is.
But a mistake.
Somebody will take a certificate copy and start creating some problem for him tomorrow. Yes, next. 30.
Advance matter, my lord.
December.
Item 30 is print for next week.
Next week may not be possible.
May frame, my lord.
On request after two.
Right.
Yes. Yes.
31. May frame, my lord. I will withdraw this afternoon. I will file a fresh application.
Do whatever, sir. I don't know. This has gone on record. You want to withdraw the affidavit? I will permit you to withdraw. Land Counsel for the petitioner, directly. Land Counsel for the petitioner seeks to withdraw the affidavit filed by the PW 1 and 2. Vijay Kumar. What is this? Vijay Kumar and
Vijay Kumar Singh.
Vijay Kumar Singh and
Srimati Singh.
Srimati Singh. The affidavit dated, which dated so also filed by Vijay Kumar Singh and Srimati is taken off the record and with the liberty to the petitioner to file fresh affidavit. Yes.
In the interim order,
no.
Interim order.
No. Because of your conduct, nothing can be given. Yes, next.
31.
May I please? You should be fair to the court and fair to the litigants. I said, you can't do that. Yes.
No, please. But this is the rules of the wiki that the petitioner accused in way of Orissa Exchange Act.
Yes.
There happened
where is the order of magistrate?
Annexed.
Annexed?
Annexed 7 to 11. Annexed 1.
7 to 11. Court order. Where is the original order?
Learned court below. Challenging that order also.
You are challenging, but where is that order?
Learned municipal.
Obviously, this your order you have filed. Let counsel for the petitioner seeks to place and record the additional document to substantiate his case. He may do so within a week. Please the matter. Yes.
So yes.
File that application and use. Yes.
33 and
33 and
15.
Yes. 33 and 15 also. Yes.
33.
Yes. 33.
Item 33, my lord.
You are agreed by what?
Rejection of petition under section 205 petition, my lord.
Yeah.
In the main code below. You grant that.
And here challenge it because you have been not cooperating, therefore the time is getting delayed. So he has filed item 15 for expedites disposal of the.
This case, my lord. The
Yes.
OP number 2, OP informant, the tenant of a person or building of the petition, my lord.
Not on merit. Why can't you appear in the court? Merit whatever may be.
Yes, my lord, because petition is an important purposes. What we are outside.
Where are you posted?
My lord, para 8, my lord, para 8.
Bangalore.
And the petition of the OP number 2 also files 7 suit against the petition.
That is not merit. I am not conscious of merit. Yes.
But on that,
he is staying there in Bangalore. Every time he can't come.
on 26 7.4, his application on P17 CRP was also rejected by court below. In my application number, page number 74.
Yes, in your matter.
Yes, madam.
That is 15.
Yes, madam.
Okay. Yes. Yes.
But he has signed actually after the filing of this application, after cognizance has been taken, at the time of cognizance he has filed the bill. He has signed that, and he stood up after that time, but he didn't appear and went to Bangalore. And despite
when required, he will appear. Even when required, he will appear. Formal hearings, he may seek exemption.
But both the 205 317 has been rejected by the
rejected, that's all right. But see, if you create that kind of stumbling block, the trial will not proceed. The idea is to see that the trial should proceed.
Yes,
as the expedition is
we also want that.
And at the same time, he is staying in Bangalore. So it's better that as and when required, he will appear in the trial court without asking for an unnecessary adjournment. And whenever formal proceedings have to be taken up, that time he may move an application. So that both the matters can be, taken care of, isn't it?
So my prayer is that
384 is concerned, your lordship. Extortion is part 388, 384 is the offense as well.
As and when required, he will appear. Okay. The other time when you are moving application, you have to appear through VC.
Yes.
That regard,
yes,
for trial court,
yes,
for appearing on a VC.
Yes, ma'am.
As and when required physical appearance, you have to come.
Yes,
that's simple.
Yes, they can appear, he can appear to VC. I have no objection.
Yes, I don't.
But stay should not be granted for that lower court proceeding. He has for a stay.
No, I will dispose it of what was yes, both the petitioner will right? 15. The present petitioner is the informant. In the Kandagiri PS case number 432 for 2020, and opposite party number, you have not implemented. Important. In the present petition, petitioner being the informant seeks a direction from this court for expeditious disposal of the trial. The counsel for the petition contended that despite the fact that the petitioners, the application of the accused under section 317 CRPC and 205 CRPC has been rejected, the petitioner is not cooperating with the trial, as a result of which the trial is prolonged. Hence, he seeks indulgence of this court. Indulgence of this court. Accused, one of the accused in the aforementioned FIR, Deepak Patnaik, has also filed criminal MC number 3982 of 2024 inter alia. It was common with the order inter alia praying that inter alia seeking quashing of the order dated 11/3/2024 passed by JMFC 5 Bhubaneswar, whereby his application under section 205 CRPC for exam CRPC has been rejected. Heard both the counsel for the petitioner as well as petitioner, both the counsels appearing as petitioners in the aforementioned CRLMCs. By taking into consideration the material placed before this court in both the petition, I am arrive at a conclusion that the trial of the case needs to proceed uninterruptedly. Therefore, at the same time, it is relevant to mention that the accused who is the petitioner in the CRLMC 3982 of 24 is concerned, he had been staying at Bangalore as he is employed there. Therefore, it may not be possible in his part to appear before the court on his date appearing. Therefore, he had moved the application under section 205 CRPC, which has been rejected by the impugn order dated 11/3/2024. Next one. Keeping in view the aforementioned, this court the trial court is directed to proceed with the trial by allowing the petitioner in CRLMC 3982 to appear on VC. However, the said petitioner is required to appear before the court physically as and when the court directs him to appear. Therefore, the petitioner is directed to move appropriate application on each date of hearing. Each date of hearing in the event he seeks to appear through VC. And it is also very clear that under no circumstances the petitioner accused shall be allowed to seek unnecessary adjournment. The trial court is expected to do and to see that the trial of the case is procedural at an expected pace, so that the same could be concluded as expeditiously as possible. With this observation, the petition is disposed of. Both the petitions are disposed of. ठीक है observation I made the observation. Yes
34 the petitioner finally FIR before the Agency has filed a complaint.
Yes.
The appellate court directed me to deposit 60,000 rupees. The appellate court directed me to deposit on section 148 of NI Act to deposit 60,000 rupees, which I could not deposit in time. So the order was cited. Evidence that I have before this.
Where is that order? Where is that order?
Order is not as per
Page
this 36 order.
36. Okay.
The petition for bail and suspension of sentence and stay relation files are taken up for consideration. Considering the nature of offence and sentence imposed, the sentence filed on civil response in one case number is suspended till disposal of appeal. The appellant is directed to deposit rupees 60,000. That is 20% of fine oblique compensation amount.
Yes.
That order
60 days.
60 days.
Till the appellate is not the bail, the vacancy person along with the suspension sentence of relations fine amount is hereby vacated.
Yes, next month.
And is taken into custody.
Yes, madam.
Now you are going to deposit.
Yes, I am ready to deposit, madam, before the appellate court.
Where is that?
That I will deposit, madam. I have not.
60,000 you want to deposit?
I will deposit.
When?
Within 15 days, madam.
That order was passed in 7/12/2023, Lordship. Whatever.
All right, 138, how many days you keep? And if you don't deposit again, the same order will be passed. Why are you not, I told you yesterday when you mentioned, come with the money, I will immediately pass the order. Do you have any instruction in that regard?
Yes, I have instruction.
I'll give only 1 week.
Yes.
Okay, right now.
From the date of issue, that body.
Petitioner, what is the check amount you tell me? Petitioner has been convicted.
3 lakhs, madam.
Yes.
Compensation amount is 3 lakhs.
Petitioner has been convicted for offences punishable under section 138 NI Act for having NI Act by judgment dated 6/11/2023 passed by JMFC Kujongo in 1 CC case number 105 of 2017. Against the said judgment of conviction and order of sentence, petitioner preferred criminal appeal number 19 of 2023 before the additional district and session judge Kujongo. While order dated 7/12/2023, the appellate court, while admitting the appeal, enlarged the petitioner on bail with a direction to deposit 20% of the check amount, compensation amount within 60 under in person under the provisions of section 148 capital A of NI Act within a period of 60 days. The petitioner could not deposit the said amount within a period of 60 days. Therefore, by the impugn order dated 29/7/2024, the bail order granted in favor of the petitioner has been vacated and petitioner is taken into custody. Hence, the petitioner is agreed and filed the present petition. And counsel for the petitioner submits that the petitioner may be released on bail. So that within 1 week from release.
There is 2 holidays there. So it is not 10 days.
Sorry?
There is 2 holidays. So it is not 10 days.
Okay. Within 1 week from the date of release, 1 week from the date of release, he would make good the payment as per the direction of the appellate court dated 7/12/2023. Regarding head to the statement made at the bar, I am inclined to allow the petition. The petitioner shall be released on bail in terms of the order dated 7/12/2023 passed by additional sessions, additional district sessions at Kujango with the condition being quick and proper, so and so, and subject to the petitioner. So the petitioner is bound down by the statement made by his counsel at the bar, and he shall deposit the 20% of compensation amount, as per the direction of the appellate court within a week from the date of release. Failing which, the concession guaranteed by this court by the present order shall stand vacated. Yes. Within 1 week, if you don't deposit, you're done. Yes. Dispose of.
Yes, Your Lordship, my lord. My lord, this is a case.
Take the order today itself. Take the order to come out. That is what they put. Yes.
My lord, the case is for passing of the DB case, my lord, on the ground that without following the rules and regulations in the DB Act, my lord.
You are husband.
My lord, I am the husband. And the petitioner number 2 is my 78 years old mother is committed suicide for this reason, my lord. And this first case has been registered.
Petitioner number 2 has died.
My lord, in the meantime, my lord. ଆଜି ସକାଳେ ମୁଁ ଘର ସେ ସୁସାଇଡ କରିଦେଲେ ଏଇ ନୋଟିସ ଯୋଉ ଗଲା ତାକୁ ସେ ଡରେଇଲେ ଆଜି ହଉଛି ବନ୍ଧା ଏବେ 78 years old ସେ ଓଲ୍ଡ ସେ ସୁସାଇଡ ସେ କରିଦେଇଛନ୍ତି ଆଚ୍ଛା ବର୍ତ୍ତମାନ already there is a divorce case is pending with the court, my lord.
Petitioner submits that in so far as petition number 2 has expired. Therefore, therefore, the present petition for the petition number 2 stands abated. Issue notice to opposite party number 2. Here's
the party member, the petitioner member, he is the son of the petitioner member.
What is name? Saez? What is
Saeb Raj.
Okay. Issue notice to opposite party number 2, returnable within week.
1 and 2, my lord.
2 is a minor.
He will
be represented by 1 only. Why should I issue notice? 1 returnable within a week. Within a week.
Proceeding
no, problem is he asking for maintenance?
Yes, my lord. Since is working, my lord. She is a constable, my lord. She is working as a constable and also the.
Where have you said that you should?
My lord.
She is working.
My lord. My lord in para 7, my lord.
Have you said that?
My lord. And also, my lord, in this case, my lord, a particular thing has happened, my lord. The advocate.
She is working. No. There is no problem in maintenance. That is the idea. Okay. Written so and so. In the meantime, so and so proceeding is stayed. Further proceeding so and so is stayed. Okay. Give the copy of the petition. But in the case. Yes.
36.
May it please your lords.
Yes.
Still, I kindly told to age 7.
Yes.
Suraj Kumar Das versus Saraswati Sarpati opposite party.
Yes.
There is a divorce suit. This I have to then your lordship may kindly turn to page 8.
Page 8.
Page 8.
Okay.
A joint petition for compromise is presented by the plaintiff and the defendant and duly signed by the parties.
Yes. Now divorce.
Divorce is granted. Now the question is the terms and conditions. Your lordship may kindly turn to page 11.
Yes.
The defendant, in view of this compromise, undertakes to withdraw the GR case number 175 of 2009.
Right. Issue notice to the opposite party number 2. Mr. Vishwal accept notice for the state and waives the notice and returnable within 2 weeks. 2 weeks. In the meantime, proceeding before so and so state. Yes.
37.
And you have paid the alimony and all?
Everything is over.
Petition for lordships. Petition number 1 was a government servant, by public servant.
before much after his retirement, he was charge sheeted under section 31E of the PC Act for the allegation of possession of disproportionate assets. Petitioner number 2 is the simple housewife, and she has been added as an abettor under section 109, contrary to your lordship's decision in Sonata case. However, these two petitioners, the charge sheet has already been submitted on 30/9/2023, and cognizance has been taken on 22/4/2024, and immediately they have appeared voluntarily before receipt of summons on 29/7/2024, along with the 205.
Who is Jitendra Maku?
You are the public servant who has been charge sheeted under section 13(1)(e) of the
Asking for petition number 2 or 1?
Both. Both are the petitions, sir. And petition number 2 has been added as a housewife, has been added under section 109.
Okay, concentrate on petition number 2. Forget about petition number 1. Petition number 2, where is the charge sheet? Let us see charge sheet. Where is the charge sheet? What is the allegation against petition number 2? No case is made out in so far as petition number 1 is concerned. And now concentrate on petition number 2 only. Let us see what are the allegations.
Petition number 2 has been added only under section 109 IPC as an abettor.
Okay, it's all right.
Outside. And my allegation is that 205 petition has been rejected. That's simple. And if your lordship kindly come to page 46, the ground taken by me for 2005 petition, your lordship may be satisfied.
Yes.
We will come to page 42, my lord. May I place it?
Yes.
Page 42, paragraph 8, that accused number 2, Srimati Surekha Mahakur, is a lady aged about 53 years, and she is suffering from diabetes, blood pressure, typhoid, arthritis, and accused number 1, her husband.
Where is your application? 205 application.
That I am reading, that page 46 I am reading.
46.
Yes.
Yes.
The relevant question I am reading. And you also may come down to page 45, paragraph 5. That the accused person before issuance of summons by this honorable court appearing voluntarily before this honorable court today through their advocate duly appointed by them. Then your lordship may turn to page 46, paragraph 8.
Paragraph 8.
Yes, ma'am. That the accused number 2, Srimati Surekha Mahakur, is a lady aged about 53 years and she is suffering from diabetes, blood pressure, thyroid, and arthritis. And the accused number 1, her husband, who is aged about 60 years, is taking care of since 2010. The photocopy of the prescription of the accused Surekha Mahakur.
No, see, both the accused cannot be exempted. Think of both.
That is accused number 1, 2 may be a simple housewife and added as 109, contrary to your lordship decision in Sonata case.
Letter.
Who was the senior state responsible for vigilance before we proper plots. We understand that out of the 2, 1 dissolved.
The lady may be exempted and later appear through VC. Lady will appear through VC.
VC may not be available.
What? Now everybody can appear. Show your face to the court.
May I confess one thing, my lord?
Yes.
As in today, my lord, I am unable to do this VC. Maybe my decision, but whatever that.
No, nowadays don't worry. Everybody does it.
Mine is very much welcome.
Madam, it is agreed by the order. Which is the order? 23 annexure? Impure not 1. Yes, petitioner is agreed by the order dated 23/9.
Yes, ma'am.
23/9/2024, whereby his application, their application, petitioners, their application under section 205 CRPC has been rejected. The petitioner number 1 is the alleged to be the principal accused, whereas petitioner number 2, being the wife of the petitioner, number 1, has been arraigned as a co-accused under the aid of section 109 IPC. 109 IPC.
Madam, I beg your pardon, madam, that may be a small mistake, my lord. The petition has been submitted on 29/7/2024.
No problem. Both the petitioners had moved the application under section 205 CRPC seeking exemption from personal appearance. The trial court has rejected the application by the impugn order. in the application, the petitioners have taken various grounds, including the following grounds. Para 5 at page 46 and para 8 at page 46, 45 and 46. Okay.
Mr. Mahapatra's given a details diseases.
Everything is given therefore. This is how the youngsters should learn. See, I have been losing my temper because of the epidemic. They should sit in the court and see how the way the so meticulous pleading. And it is so easy for the court also to
Quote it.
This is how the all youngsters are shortcut. In one case, one affidavit is filed. That is POCSO and 376. And the other case is 307. Copy paste. Just imagine. And where we say that's a settlement. What to do?
In their present, the prisoners are taking various grounds, including the following grounds. Para 5.
Para 5 and 10.
Para 8.
Mr. Mahapatra, learned counsel for the petitioner, submits that, fairly submits that insofar as petitioner number 1 is concerned, the trial court rejects, the trial court might be correct in rejecting the application. But insofar as the petition number 2 is concerned, the trial court is absolutely wrong in rejecting the prayer made by her under section 205 CRPC. Taking into consideration the facts in entirety and the grounds urged by the petitioner, I am of the considered view that the application moved by the petitioner number 2 for exemption from personal appearance ought to have been considered sympathetically in view of the fact that she is neither the principal accused, she is not the principal accused, and she has been suffering from various ailment. She being a housemaker, a lenient view ought to have been taken. Regarding head to the aforementioned,
Indirectly say that the basic can be resorted.
No, that's what I'm saying. Regarding head to the aforementioned, liberty is granted to the petitioner to reiterate her prayer before the trial court by moving a fresh application under 205, praying for exemption from personal appearance. The trial court shall sympathetically consider the application and allow the petitioner number 2 to appear before the court through video conferencing mode on all the formal dates. However, as and when the physical presence is required, as and when the physical presence is imperative, the trial court may insist the physical presence of the petitioner number 2. With this observation, the petitioner is disposed.
One thing further, may I like to submit, my lord, I am really extremely sorry by my lord of friends comment praising me, but I am not worthy of that. I have 2 mistakes in my petition.
That's still goodness.
Where is that, sir? Page 1, in the post title itself, in the matter of vigilance, it should have been Sundargarh. My lord, it's a mistake.
It is not the mistake, it is typo.
Typographic mistake.
It is a typo that can be corrected.
Same thing, page 4, last line.
Physical copy is there. Soft copy is there. Then Mr. Mahapatra, learned counsel at this stage submits that there are 2 typographical errors which has occurred in the petition. Occurred in the petition. He points out that at page number 1.
Page number 1, Hon'Ble in place of Sundargarh.
In place of yes, in the first title, in place of it should be Sambalpur.
No, that is wrong in taken as Hon'Ble, it should be Sundargarh.
But it is written Sundargarh here.
No, page 1, Sambalpur.
No, in my petition it is Sundargarh. Very boldly it is written. Your junior might have done it.
I was ill at that time, but he did.
Your junior has done it, don't worry.
I took up the responsibility.
Thank you.
blame others.
Thank you. Cut this, okay.
Further difficulty is while the case is placed on 11th. I can't get the copy. So if my foreign friend can check.
11th, you will get the copy. You will get the copy.
Or else I will download. I will supply.
Yes, yes.
Yes.
38.
It was previously found to division for pretty long time.
Very long time. And you people are product of him.
It's difficult to follow his footprints, but still is an able to.
Yes. Yes.
The question of the proceedings between the petitioner and the appeal number 2, arising out of a 498 and other cases, my lord. And annexation 1 is the fair. 492, 417, 420, 419. No, because they had a living relations for since last 22 years. They are the doctors.
I'll issue notice.
Yes, madam.
Issue notice. Called opposite party number 2, Mr. Bishwal waives notice for stay. Okay.
There's a
new application.
The wife has been issued again the doctor and the petitioner.
Item 37, no?
38.
38. Warrant issued.
Yes, my lord.
Where is that?
That to get page, my lord. Page 26, my lord.
26. Execution of warrant issued against the petitioner by the order dated.
Dated 29/9/2020, my lord.
29/9/2020. 2020 you are sleeping over the matter.
Now the warrant is issued since long, so it is still pending.
Shall remain kept in events till next date available. Yes. Yes. You file the process letters.
Yes, yes.
Yeah.
Okay.
40.
Yes, sir.
Losses are directed me to product the entire police paper.
Whether this petition is public servant or not, my lord.
The thing which you have given me now is thicker than the
Entire investigation paper.
to file it, let them have the privilege of reading it.
I have given
such a big volume.
I have given.
I will venture it. I will venture and look at the request some reading time.
Let them see, because it will take time immediately in the court. They may not. Just file it and keep it big.
Then you have
week after.
Tomorrow. Then
Tomorrow may not be possible. Monday, Tuesday. File it immediately. With the paperless thing, where will I keep it? That's another problem. Yes. Tuesday, yes.
41.
mostly half mark of it.
But looking into the volume, I am sure that you don't have a case.
Most likely, Mr. Manthi will put some flat next time. The flat release of the
Flat second paper late. My lord, may you lastly keep it on
Tuesday.
mounted.
Monday will be heavy day.
I will be in difficulty. Or on 25th, my lord.
Okay, 25th. 25th. You file it so that yes. Yes. 43.
42.
42, na?
41.
Withdraw.
42.
Yes.
Petitioner was released on 12 March 2015 and imbue was issued on 16.
Where were you? 2018.
The communication with the
P1000. Okay.
43.
May I have legal lordship? Inimitable order 5/8/2024 passed by non JMFC LR Onuguru. Bail order.
Bill 69/2011. NBW 58/2024. 500. Yes.
44.
Petitioner was earlier on bail on 12/3/2024. The petition filed and time petition that was not allowed because of year-old case. NBU has issued another petition.
NBW issued on?
And 12/3/24.
24.
Yes,
500. 500. Wait, please repeat once again.
12/3/24, page 14.
No, bail order.
Bail earlier was allowed, but he has after charge sheet, previous bail is continued on 23/2/2022, page 12.
Yes.
23 to 2022.
Okay, 500. Yes, next.
45.
Lordship. Evidently issued on 5/10/2023, my lord.
5/10/23.
23. Bail on 13/10/2020.
13/10/20.
Yes.
3 of you are there. 3.
Okay, lord.
1,000. Yes. Next.
Yes, my lord.
Excuse me, Lord.
Petitioners have been released on bail on 28/2022. The warrant has been issued on 9/7/2024. 9/7.
How many of you are there? 2.
500 each. My lord.
7 each.
57.
My lord, the Belgium matter, the petitioner was released on bail at 16/9/2008 and the NBW was issued 27/9/2023.
2023.
My lord.
Okay, 500. Yes.
Problem.
48.
Yeah. Application for bail may also. Petitioner was before lawsuit earlier may also prior to filing of charge sheet. Lawsuit has granted liberty to move minutes after charge sheet or after charge sheet have come up. He is in custody.
CD there. Call for CD. Call for CD. After one. Yes.
49.
Yes, may I pray one thing. Case diary is available in the connect to in the case number of the DLAPL number 2196 of 2024. My friend can make an effort and trace it out so that it can be
2196.
Yes.
24.
yeah.
Just check it up.
24.
After 1 week, yes. Yes.
49.
May I please the Lordship? Lordship, I am through BC Lordship.
Yes.
Lordship, here the offences are initially registered under section 4.
Any, you got CD case? Got it?
Lordship, magistrate have all offence, sir.
What to do? There is a change of guard. Get the CD. Because these are bail matters. We can't wait for a longer time. Okay? Get the CD.
Lordship, for a second only, Lordship.
Yes, after 1 week. Yes.
50.
Yes.
Your my lord, other co-accused person's bail application is fixed to 12.
What about this case?
OCD.
Call for CD. After
Other matters are fixed to 12, my lord. Co-accused persons are 12.
12 co-accused person. 12.
51.
May I please, Lordship? Here the bail application of the petitioner was earlier rejected by the Supreme Court due to non-submission of charge sheet, and after charge sheet I have moved my bail application and it was also.
Yes, got it.
Yes.
Yes.
The petitioner is in custody since 15/1/2004 in connection with 15/1/2024 in connection with another case. During his stay at custody, in this case he has been remanded on 19/1/2024. The case of the fact of the case is like this: the present petitioner snatched a motorcycle of a unknown person on 28/12/2023. May I read the affair? On 28/16/1/2024 लिखिले ମୁଁ ରାକେଶ କୁମାର ସାହୁ ବୟସ 26 ବର୍ଷ ପିତା ସେନା ବଲ୍ଲଭନ୍ଦ ପଟସାରୀ ଇଲେକ୍ଟ୍ରୋନିକ ମେକାନିକ ଭାବରେ କାମ କରୁଛି 28/12
How many cases are there against you?
4 cases are there. No, 4 cases are there. And out of which I have already released in 3 cases and this is the last case pending.
Have you filed the affidavit?
Yes, my lord. Earlier I have filed the affidavit, my lord, and it is copy of the affidavit is available with me. The mother of the petitioner has filed the affidavit. Nahi.
But this affidavit is not signed.
Original affidavit has been filed on file number 7415. Earlier bail application which was rejected, my lord. In that bail application,
In that bail application, you file in this bail application.
yes.
Then counsel for the petition seeks one time to file affidavit detailing the antecedents and the status of those cases. Yes. Yes.
Copy this or
Copy we shall order.
Yes, yes. It will be taken up on Monday, if possible.
Not Monday, we will give a date. Yes.
52.
My lord.
The Lordship may fix up the date so that it can
He'll fix it.
Yes, my lord, the affair has been lodged in the year of 2018 against unknown person, my lord. Thereafter, the crime branch submitted final form as mistake of fact in the year of 2019. Thereafter, the IIC, then on 30 the opposite party number 2 has filed a protest petition
on where the loan magistrate JMFC Vasudevapura has taken cognizance. And
Cognizance,
on the protest petition, my lord.
how offenses?
Offense, my lord, under section 302 and other allied offenses.
You are in custody since?
My lord, I am surrendered on 27/2024, my lord. And in the meantime, my lord, all the co-accused persons have been released on bail, my lord, by this honorable court, my lord.
Where is that?
My lord.
Where are those orders?
Okay.
Yes. The same case.
My lord, same.
Yes. He initially FIR was registered, and the informant was not satisfied. He said that it should be investigated through CBCID. CBCID is also investigated. File a closure report. Then the protest petition filed. And in the protest petition now cognizance is taken. You can't keep them like this. Right? Petition is in custody since 27/9/2027. I will give you facts. Okay. The all the co-accused persons, namely, so and so have filed so and so petitions. Okay, filed a petition. All of them have been enlarged on bail while the order dated so and so. Petition is in custody since 27/9/2024 regarding yet to the period of custody and not granted. Yes. Hello. Yes.
53.
And if it would action, so it would leave that. Yes. Yes. 53 non-appears for the petitioner in the interest of judge.
54.
Can we keep tomorrow man at Mr. Bikaras and next week for
after 1 week, yes. On request, yes. 55.
54 inside.
Advantage. Yes. You will give it, yes.
May
Right.
The petitioner is in custody in connection with the offense under section 420.
You have CD and all this. Let me see.
For the informant in this case.
My lord is appearing for the informant. And I must recollect the previous proceedings. As because the medical proceeding was there fixed in respect of another person who is in fact involved in the kingpin of the present case. He has taken all the money. The transaction was done through the present petitioner. The petitioner being the employee of that person, he is the builder. I am the worker. In my name, the builder purchased one plot. Thereafter, that plot was sold to the client of my learned friend. And subsequently, it was found that the plot in question has been transaction was made, even if in my name, all these things were caught. So, impersonating some other persons, the land initially was registered in my name. Thereafter, from my name, it was registered to my learned friend's client's name. So, for this transaction, my learned friend's client has submitted, given the amount. And when the dispute arose after being received of the summons from the civil court filed by the original owner, all these things came into light. And when my learned friend's client demanded money to the present petitioner, the petitioner also showed that all the transactions which were made, all the money has been transferred to that person. So that person was taken all the money. I was being the employee, discharged my.
He got the bill.
He has been released on bail. And in the event of which granting bail, he will also directed for mediation proceeding. In the mediation proceeding, as my learned friend will apprise what happened on 30th.
Because on 30th, the petitioner in that case
has categorically denied that any amount has not been disbursed to the account of that petitioner, and all the amount of the employment is in his custody. So, my lord, at this junction, may I pray that yes, my lord, that for that extent, my lord, may I pray that
Will be better after putting there.
my lord, that will not suffice with the purpose. He may be released on 18 bail, and he may participate in that proceeding, so that that will suffice the purpose. Will you be ready? Yes, my lord.
I don't know.
I will give entry to and go on participating in that mediation center.
Yes, sir.
And insofar as the regular bail is concerned, I will give you 2 months bail.
1 month, my lord.
2 months.
That will be my lord.
Your lordship may request your lordship to keep this matter.
No. I'm tempted to dispose of. Therefore, I'm saying
Lordship may,
after 2 months it may be settled.
yes, my lord.
No, that
No. If there is the pressure, then only we will settle. Otherwise,
no, that is right. That is why also
he say 1 month, I'm saying 2 months.
I'm not trying to put more pressure on my client by keeping this case pending here this alone.
No. He must know that after 1-2 months I have to surrender if I am not settled to this issue.
6 weeks.
You may ask for extension of time. That is story.
That will also indicate by keeping these bail applications are pending. No extension into that.
The co-accused, where is that bail order?
Bail order is, my lord.
The main judge is a regular bail policy.
You will also get regular bail working.
No, it's regular bail.
Krishna Chandra Chaudhary, alias Pukuna, approached this court by filing BLAPL number 5887 of 2024. This court, by order dated 18/9/2024, enlarged the petitioner on enlarged that petitioner on bail, and also referred the matter to mediation center of Orissa High Court, mediation center of Orissa. Mr. Mahapatra, learned counsel for the informant, submit that the mediation process is still going on, and it is now fixed for 14/11/2024. Mr. Mahapatra, learned counsel for the petitioner, submits that the case of the present petitioner is present petitioner is in better footing in comparison to the co-accused Krishna Chandra Chaudhary, and he seeks parity with the said accused. Since the mediation process is going on, I'm of the considered view that the present petitioner shall also participate in the mediation proceeding. Hence, to begin with, I am using the expression to begin with. To begin with, the petitioner, present petitioner, shall be enlarged on interim bail for a period of 6 weeks. I will include the time period of 8 weeks. 8 weeks, so that he can participate in the mediation process and and explore the possibility of settlement, the entire dispute. The petitioner is also at liberty to seek extension of time if the mediation process will not conclude within this time. Insofar as the main prayer of regular bail is concerned, the petitioner may renew his bail plea after the conclusion of mediation. Therefore, the petition is disposed of with a direction to the trial court to release the petitioner on interim bail for a period of 8 weeks, period of 2 months. 2 months on the condition deemed fit and proper.
Dispose of the bail application,
subject to condition that the petitioner shall cooperate in the mediation process.
The application be kept in pending manner. He is being released on interim bail manner.
and granting interim bail, bail petition dispose of with liberty to remove the bail plea before the trial court once the mediation passes.
Why I was suggesting for keeping the bail application pending, in that event what will happen in the event the matter is not settled. In the event the matter is settled, then also the petitioner has to go to custody for some time.
In the event the mediation is successful, petitioner is also at liberty to move this court by way of an IA for grant of regular bail. Yes.
My lord, damages
successful.
Yes.
My lord, may just reflect that the mediation
because of the special leave there is
Yeah. My lord, may I submit one thing? My lord, may just reflect the mediation.
I was complicating so much.
Mediation proceeding number so that will.
It's all right. You are interested in your money. Under pressure, they will give you and finish it.
My lord, number may be reflected. That is what I am submitting. Mediation will take. Yes. Mediation proceeding. Yes, my lord.
ଏଇଥିରେ ଅବିକା ଇଏ ଗଲେ ଭିତରକୁ ୟା ପରେ ପୁଷ୍ଟତନ୍ତ୍ର ଭିତରକୁ ଯିବ ଇଏ ବାହାରକୁ ଆସିଲେ
ଇଏ ଆଉ ଗୋଟେ କେସ୍ ଫାଇଲ କରିଛି 1cc
ସେ ଏମିତି କରିକି ଫସେଇଛନ୍ତି ବୋଲି
You get your money and be happy either from him or from Procedural, but you get your money back.
My grievance would be redressed by that.
Yes, that is true.
My lord has directed the State Council to take instruction on the IA that the wife of the petitioner is ill.
Where is that application?
IA number.
Issue IA number 1419.
Yes, ma'am.
I issue notice in the application IA number 1419. The State Council is directed to verify where is the certificate?
My lord,
verify the health condition of the wife of the
3010 my lord has directed State Council to take instruction on 3010.
Already?
Yes, my lord. 3010 to 30.
Have you got any such? On the interim application, direction was made to the State Council on 30th October 2024 to seek instruction regarding the to verify the health condition of the wife of the petitioner. The Mr. Tej Pratap, Counsel for the State, submits that he has not yet received the instruction. 1 week time as the last opportunity is granted to obtain instruction is the matter of. Yes.
But I may pardon on Wednesday pursue. Wednesday 13. 14,
13.
14 motive assumed as 13.
13. Just verify if she is not well, then yes. Yes.
That is CMQ filed for non-compliance of the peremptory order passed on 7/12/2007.
7/12?
7/12/2007. I quote the order.
Where is that?
That is quoted in page 3 of my restoration application.
Restoration?
Yes.
For the reasons stated in the application, the what is dismissed? Where is that?
Dismissal.
Where is that order? Dismissal order.
This is not
where is the dismissal order?
That I have quoted in my. But I understand that that is.
You are challenging an order that the order itself is not there.
I understand that. I understand.
You don't know what is you are telling. I don't understand.
No, that is.
Where is the order? Which order I said, sir?
This is order there 7/12/2007.
Where is that order I am showing? I am asking.
The order is. I just this government.
At least this order is minimum required.
Yes, I understand.
By order dated 7/12/2007.
Yes.
The appeal. This is the appeal. What is that? CMAPL number 566 of 2015 was dismissed for non-prosecution for the reasons stated in the application. The file is restored to its original. The case is restored to its original file. What is the merit you have? Yes,
merit is not the. There is no such allegation against the revenue authorities, but the jail authority now released the person. Therefore, I have been saddled with cost and consequence by the.
There was the delay. How much delay? Because 2007 it is.
Yes. That I have explained, my lord, each and every day I have prepared the date chart.
Where is that?
If you are kindly see my date chart, and it can be convenient for us.
No, where you application?
Yes, I have explained.
Sufficient reasons.
Yes, my lord,
Yes.
I have, yes.
So,
My lord, your lordship see the date chart, then I'll become.
in the application you show me.
Yes, my lord, I'm in the application.
Sufficient reason is to be shown in the application.
Yes, my lord.
Yes. Only after receiving the notice of execution in 2015.
Your lordship, the RSA, my lord, the matter was dismissed, my lord, 7/12/2007 order. Thereafter, my lord, the senior standing as were appeared, my lord, he was changed the office. And then, my lord, he was again reposted as a senior standing of my lord, Central Excise Department. And my lord, in between, my lord, the person advocate has filed a memo with the my lord, certified copy of the dispensing, the order of the certified copy is filed, but it was misplaced. Then we reconstruct the file, and again
This application has been filed when?
this application was filed not
2015.
yes, sir.
The restoration application was not listed since 2015.
Yes, sir. But I am most frustration that I have listed this. After I gave the file, not.
I thought it is the application recently you filed.
I am sorry, Lord. It was not. Only the 4% has crossed in the meantime.
For the reason stated in the application, the same is allowed. Application under section 5 of Limitation Act for condonation of delay in moving the application under section 151 CPC for restoration is also, this is
RSM, no?
RSA, na?
Yes.
Is also allowed for the sufficient cause
yes,
shown by the petitioner, which is enumerated in para 3 of the application. Means the matter, that is RSA number 161. It is assigned to me. Just check it up. How it has come to me.
It's not. It is. It is a lot because.
Just check it up. How did it come to me?
Same to RSA.
No, RSA is the original.
Yes.
The application. It is there with us? Okay. Allowed.
The 3 court.
Least the RSA before the assigned bench. Assigned bench.
Next to it. Kindly keep it the date because otherwise not. CP has been already executed against not the personal appearance.
7 it was.
I understand. I am not.
And second appeal.
Yes, Lord. I understand it is our difficult. I only
maybe concurrent finding against you. Nothing is there in the RSA, I know that. Yes, means the RSA before the assigned bench, subject to the approval of the Honorable Chief Justice.
Much.
Yes.
Lord, I am 53. I'm sorry, Lord. I could not reach in time. Lord. I took 53.
53? It's simply urgent. They are also not ready.
Next Monday.
Yes, next.
Next Monday.
He was given a date, yes.
8. The restoration. Serial.
Restoration?
Yeah.
Is there any delay? How much?
I became the. My power is there.
This case is not.
I found support.
Delay, how much delay?
536.
Huh?
536.
536 days.
I moved to the person was.
Where is written delay?
Everything.
Where is the application? Where is that application? Where have you written that?
44/2024.
44 or 24, yes. So many sufficient reasons. Para 3.
Yes. Delay for about 536.
No, why? Explain the delay. Where will you explain? Sufficient reason has to be shown.
Para 4.
Para 4.
Due to I'm conducting nursing. Nursing knows I cannot also place that genuine things I have given. But I cannot say that I have been recommended as
I know. What can you say? You know that better than. How can you say that due to ill health of the conducting counsel for 500 someday ill health?
That he was the junior and he was
No, file a better affidavit. File a better affidavit. Give some sufficient reason, some semblance of some explanation. What do you say? What do you say? You tell me whether, do you have a case on merit?
Yes, that is fine. Otherwise, why should I find this restoration? It's a case, it's a genuine case. When I will have.
And this CRLMC is in our assembly? In our assembly?
Yes.
List this present petition along with the CRLMC so and so for hearing on give a date. You prima facie satisfy. If you have a case on merit, I'll restore.
Right.
If there is no case, both the things are dismissed.
Right. Right.
That's the better idea.
Yes.
Okay.
Without restoring.
No, tag and see. I want to see. It is already there. List it for hearing. You satisfy me in the CRLMC. I'll hear that. I'll not hear it. If I'm satisfied there, if you have a case, I'll restore it and allow it. Right. Or do whatever. Right. If you don't have a case, I'll dismiss it so that automatically that is also dismissed. Okay. Yes. Simply list. Because I'm not satisfied on your I know you release this application along with the file of that case. Yes. Simply urgent, get ready.
Put a date.
He will give you date. Get ready and address on that.
Yes.
Yes. I'm not indicating anything, but get ready in the main matter. Yes. Sensory. When was it dismissed?
It was dismissed on 12/5/23.
Where is that order?
I have filed the dispensing.
It's showing that order, how it is dismissed, why it is dismissed.
For non-prosecution.
But how do I know non-prosecution on merit? Sometimes it is dismissed on merit and even otherwise there is nothing on merits. That might have been written also, I don't know. Show me that order.
It is done.
You call the SR. Let him meet. Okay. How these applications are being numbered?
Because I have filed the dispensing for that.
No, without the order which you are challenging, without filing that order, how these petitions are being numbered and listed? There is nothing on the record except your 2 pages application. The order, when it was dismissed, what was the order? Nothing is there.
I have mentioned everything.
No, I will not go by mention. You get that order. Get that order. It's very dangerous. Very dangerous. Get that order. Yes. At least after 2 weeks.
I'll file the online copy by.
I don't need certified copy. I just need. I want to see that order.
I will file.
He can do it within 2 seconds. Why can't you do it? You people are very casual. I must tell you. Nobody, nowhere in the world these things are happening. Make it an excess. Take it and make it in. Take it. For the reasons stated in the application. When was it dismissed?
12/5/2023.
2023. 23. Okay, for the reasons stated in the application, the what is that? That petition is allowed, and the CRLMC, CRLMC is restored to its original file. Original file. Lease the CRLMC for final disposal on such thing. Yes, you make that as a part of record. And counsel for the petitioner is allowed to place on record the order dated
12/5/2023.
12/5/23 passed in the CRLMC 1103 of 2021. Yes.
60.
Transfer from us. Someone appeared also in that case.
Who is appeared?
There is other names.
Still. Justice for serving notice on OP2 not yet taken.
The two steps are taken, huh? The I'll dismiss in for non-prosecution.
Petitioner has taken that file from the office file.
I'll dismiss for non-prosecution if they're interested will come. Well, right. Pursuant to the order of this court, no steps has been taken by the petitioner for serving opposite party number 2. On this non-APS for petitioner. It appears the petitioner is not interested to prosecute the present case, hence the same is dismissed. Yes.
61 was passed to you, called. 61 was passed to you. After that, I called.
When we have passed it over.
Once I called, nobody appeared.
Okay. Interim order passed earlier. Call once again. 61. Yes.
Lordship, I am for the informant. I've been instructed that the dispute between both the parties has been compromised. Lordship may allow both the parties to appear in person and file a joint affidavit. Lordship, I may.
This is NIA.
Lordship. No. Offense, ma'am.
138?
No.
What NILT says?
No, Lordship. No, I heard.
Achha. What is the offense?
Offense is under 370,
294, 320, 374, 34.
Child labor and all. Okay. I'm simply advising you to do whatever.
Lordship, may allow the matter to be posted next week.
File affidavit and all, we'll see. File affidavit, bring them.
Lordship, date may be fixed so that I can from Kenjur. From
fix the date.
26.
26, fix you with affidavit and all you come. Okay.
Lordship.
Okay.
Obliged.
Entry mode to contact, yes. Of service. Is there any entry order?
No entry order. No.
Persons to the order dated 13/5/2024. Recusals has not yet been filed to effect service on opposite party number 2. Legal counsel for the petitioner seeks 2 weeks time to file recusal. Take steps for service on respondent number 2. Leaves the matter after 3 weeks.
63.
3-4 weeks, December 5th.
May please allow. Item number 63, my lord. Honorable Court issued notice to the 2 and 3 twice, my lord. On behalf of 83, someone appeared, but
yes,
she is not present. OP2's confirmation.
Notice, sir. Notice on sub OP2.
Answer notice.
Served or unserved, but in the meeting it mentioned that item delivered.
Check it up.
On sub notice return OP2.
Unserved notice not returned.
Return.
2 is not sufficient. Take steps first.
The scrap consignment said it is delivered on 1st October 2008.
The record shows that in this report. Despite service of notice on opposite party number 2 and 3.
She's appeared, my lord. She's appeared and entered appearance. Some Clement counsel appeared.
Party number 2, the proceeding doesn't say opposite party number 2. None appears for him. Mr. Sahu appears for the petitioner. However, there is no presence from the private respondents. In the interest of justice, leaves the matter themselves. Yes.
Short date, my time.
Short date, we'll give you. Adjust and give it. Yes.
64.
So this is regarding service of notice.
In this case, pursuant to notice, I have appeared OP number 5, 6 and 7.
Yes.
This is a case I mentioned because now the case is posted for the cross-examination of the second IO. Is a fact may submit my order. Your Lordship has.
You are for petitioner.
I am for the petitioner.
Yes.
Your Lordship has taken the cognizance. Here, the case is that one advocate of a bar has been murdered at in a hotel campus. FIR has been lost. My lord, charge sheet has been filed.
Yes.
In charge sheet, my lord, your Lordship will turn to the case 36. Ramapase case of 324, 307, 302. On day 20B, 201 and 34.5. This is related to 25, 27 of Arms Act. Was well made out against the accused persons noted in page 3, serial number 13 in the final form and the section of law. Hence, you are agreed on which order? My lord, I have not agreed. I have agreed on the order rejection of an application under section 216 CRPC.
Where is that order? Where is that order?
Yes.
That is at page 122, madam.
122. 142. Yes, 120.
Yes.
That begins at 122.
Really?
Also turn to page 122, dated 15/2/2024.
Yes.
Below. If on basing on conjecture and surmises, 120B of IPC cannot be added. With the charge more so when the Hon'Ble Court by order so and so is directed, this court to conclude the trial within a period of 4 months. And it needless to say that if any offence is added to the charge at this stage, it will give rise to de novo trial. Hence, the petition has no limits. My explanation to this law, when the charge has been framed and cognizance has been taken, cognizance has not been taken, then matter is something different. The London magistrate has taken the cognizance
and 120B.
120. I have quoted in my petition itself.
Charge has been framed.
But charge has not been framed under section 120.
Have you challenged that order?
Yes. No, I have not challenged that charge. But here I have filed an application.
What stage?
Stage now, my lord, the second I used to be.
Oh, that's the problem. Stage and
I am satisfied that
you should have challenged the charge.
I have challenged earlier. This Hon'Ble Court can see annex of 5. Page 101.
5.
Yes.
Yes. Yes. Relevant part?
Yes. Operating part, my lord, is 106.
Yes.
Section 216 CRPC confers the jurisdiction of all court, including designated courts and so and so. Coming back to the case, and this court finds in force in submission of learning AG in backdrop of the principles enunciated. The submission advanced Mr. Mishra insisting interference to direct the learning court to alter the charge stands abrogated more so for the reason that in the impulse order, the learning court was categorically held. They are moved from the side of additional PP is premature, and in case subsequently substantial material is brought on the court. The liberty has been given to the additional PP. But additional PP has filed the application. The crux is that additional under annex of 6 series, additional PP has filed the application stating therein that so far the PW 11, PW 17, PW 19, they have categorically stated the involvement of the person to, I mean the wife of the present deceased, involvement and it is also the moment about the commission of crime.
Yes.
And the exhibit 17 and 18, which has been exhibited at this
Yes.
level of the prosecution below, where they are making out mind has been clearly telltale. And exhibit 17 and 18, no answer has been given. Kindly see the petition filed by the prosecution.
What is the order dated 2/6/2023? 2/6/2023. What is that order?
2/6.
Similar application already rejected. Was earlier rejected and
I prefer the application of the procedural.
Same application you moved.
he has never moved
When it was rejected, then who came to this court?
my lord. I think my non-friend was here. I think I have come. I have come earlier. That have come earlier. That has been landed, this Honorable Court directed and giving the liberty to the PP to renew the prayer.
And now the present petition is. No, here.
Here I have said,
What they are saying, let us.
they are not right because you
They are, see, your grievance is agitated at one stage. This court has passed an order saying that nothing is, no material is there. In even some material comes, then liberty is granted to PT to do something. And PT thought that some material has come. He moved the application, which is now rejected. Then that side has to come and tell me.
My lord, yes, my humble submission that
You want see from, you have informant and you have a limited role to play. That character even the High Court in the earlier round has
not touched this.
gave the liberty to the PT, additional PT.
I should not stated that provision. An informant can come. Can agitate.
Which is the limitation of 302.
But 302, your version is correct, permission is necessary. And I have the right to support the PP.
Within that,
if the PP will not
within that boundary of 302, you can,
that has been
explore your possibility. Don't stop that.
I should not say that. In Japanese case, your lordship has knows. The analysis has been made by the Honorable Supreme Court.
Yes, madam. Madam, what do you say? Are you agreed by this order? See,
State has not had. State has not accepted. State may not be, but right has been acknowledged by the informant or to say.
Now, unless the PT says that I am agreed, why should the court will give indulgence? Instruction. Because in the instance of PP, the application was due.
Yes, is correct. PP has analyzed the evidence.
Yes.
PP has stated everything.
PP is satisfied with the order. PP is satisfied with the order.
No, PP is.
That's what she says.
Let us say first. I am satisfied with that. Then I will go to anyone. Let us say, the prosecution is satisfied with the commission of offense under section 302. And why did the friends?
According to him, the informant, some material has come. You moved an application saying that 120B should be added. Trial court rejects that application. You are not agreeing according to you. And the informant has come. Informant has come. You address.
On that point,
I think she didn't follow it. Yes. The implications she might have not followed.
Yes, yes.
So let her prepare. And you please brief him. Brief her.
And
I'll tell you, I think that's your job. That is your job. Being informant, that is your job. You please assist her. And she has not understood the implication.
One more prayer can be clear. On the last occasion, you will not see first. Admit issue notice to the accused because the liberty can be granted because opportunity in that Japanese case has been categorically followed. Now, the trial is going on. Let the trial be go.
By the way, how will you agree? Madam? By the way, how will you agree with it is allowed? You are already in, you are facing the trial in 302, but if 120B is there or 120B is not there, how does it make difference to you? Particular.
But in fact, he is to say how he agreed, but who he agreed if 120B is not added.
No, the and the Supreme Court lesser offense, I don't think would cause you any problem. 302 you are facing.
Yes, we are fetching alert. In fact, do a successful application filed by the state.
That what I want to know. Are you really prejudiced if it is allowed?
Yes, madam.
What way?
Now the Supreme Court has said no party has the right to make an application to seek alteration of the charge.
That's right.
The application was dismissed. Why?
I know.
Kindly see.
Your question kindly see. Therefore, I'm saying, asking people to ask. Yes.
Let me see paragraph 6 in that judgment.
Yes.
We find force in the submission of one senior counsel to respondent 1. Section 216 CRPC empowers the court to alter or add any charge at any time before the judgment is pronounced. It is now well settled that power vested in the court is exclusive to the court, and there is no right in any party to seek for such addition or alteration by filing in the application as a matter of right. It may be that if there is an omission in the framing of charge, or it comes to the knowledge of the court trying the offence, the power is always vested in the court as provided in section 216.
264 is also there. CRPC, that also taken care. Yes.
To either alter or add the charge, and such power is available to the court at any time before the judgment is pronounced. It is an enabling provision for the court to exercise its power under certain contingency which comes to notice or brought to notice. In such situation, it comes to knowledge in the court that necessity has arisen for the change to alter or added. It may do so on its own, and no order need to be passed for that purpose. After such alteration or addition, where the final decision is rendered, it will open for the parties to work on the limit in accordance with the law.
Yes.
Yes, I am supporting this judgment. You also can see the judgment of the Honorable Supreme Court to appeal. When PPS filed and pointed out the difference.
It is not the court.
Pardon?
It is not the court. It is not the court. No, let's say come to 216, come to see 2016.
Yes.
Provision, read the provision.
In paragraph 7 also, towards middle, we make it clear that no party de facto complainant or the accused or for that I am submitting, I am not completed. De facto complainant, not the accused or for that matter the prosecution having vested right to seek any addition or alteration of charge because it is not provided on section 216.
Where you are reading?
Paragraph 7 of the judgment.
Yes.
Last 4 lines, last 6 lines rather. Yes, we make it clear that no party, neither de facto complainant nor the accused or for that matter the prosecution has a vested right to seek any alteration or additional alteration of charge because it is not provided in section 216 CRPC. If such a course is to be adopted by the parties allowed, then it will be even impossible for the criminal court to conclude its proceeding, and the concept of speedy trial will get jeopardized. In such circumstances, when the application preferred the applicant,
what is your answer to this 2 paragraph?
You also asked me to read that 260. First, that any court may alter or add any charge.
That is what they interpret. The Supreme Court interpret any court means in court only. Not anyone else.
Second, the cognizance of offense.
No, the problem, para 7 forbids you.
Yes.
Completely forbidden. The complainant. The complete CV, it says that neither the
section 211, 221 and 222 CRPC. In this context, in the light of
it says we make it clear, it's very important, we make it clear that no party, neither de facto complainant nor the accused or for that matter the prosecution has any vested right to seek any additional alteration of charges. It's completely forbidden.
I am not saying alter. My submission. Your also can for
additional alteration. Both the consider.
What is my submission? My submission charge has been framed. Sorry, charge sheet has been filed. Where 120 was there.
So right.
Cognizance was taken.
Charge has been framed.
Yes.
You have not challenged that.
I am not challenging.
Rather, you moved at one stage. You moved an application at 216, which has been rejected by the trial court. You came to this court. This court rejected your case. However, a small observation was made. On the strength of that observation, BP moved an application. That application is also turned down. And now BP doesn't have any objection. And you, as a complainant, challenge that.
So what my submission?
And your limitation is not clear.
Because if that mistrust case, mistrust case will be considered. But informant has the right to approach. Even if people will not approach. And 216 says, if alteration or addition to charge in such that proceeding immediately with the trial is not likely in the opinion of the court to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may in its discretion after such alteration or addition.
Yes, what can do it?
Proceed. Sir, I am not saying that PP will do it.
Earlier application was also not filed by him.
The trial.
Earlier application seeking alteration, that is order dated 2/6/23 was also not filed by him.
Who filed?
That can be, yes, and that can be confirmed in the statement on the annexure 5 at page 125. You have one copy?
Okay.
And there also, by considering the earlier application,
Okay. If you want to file anything, you can file.
Yes,
Let it
sir.
here.
Not I will from the and in the meantime, trial having prosecution evidence has been closed. Not closed. Yes, you do not know, you do not have the instruction. Don't say no.
My instruction will not that I also.
I'm not concerned about that. I'm not concerned. I'll only deal with the scope of 260.
Yes.
Not beyond that.
I don't. Let's omit only one. Apart from all this.
Who are you? Who are you?
I am appealing for opinion.
One of the
One of the.
You want to be allowed?
If you say there is no dispute about the fact that court has power or not, court has ample power to add or alter the charge before passing of the judge. To that effect, there is no dispute. Now the London court below, while rejecting the petition in the previous application, and which was subsequently confirmed by this court, court has given a finding that their application is premature because when a charge is to be altered or modified, finality. That must be based on the evidence on record. So the London trial court, by that time about 17 witnesses have been examined. The London trial court went through the evidence and found that there is no material on record to come to a prima facie finding that is section or any alteration of charge is required. So, on the finding that it is not at a mature stage, immature, subsequently case procedure. Now, my lord, the case I has already been examined.
What do you want to say? I don't understand.
I want to say that if any article, not only on merit that whoever people will file or he has a location to file, the London trial court has considered all the aspect merit of the case and has taken a finding.
That application was rejected on merits only. Yes, I have seen it.
Yes, on merit.
Okay.
So that may be clear.
Yes. Yes.
So that being the question, and it is here not the
And while disposing of the earlier case, target was fixed.
It is already recorded. That is in the record itself. I recorded. That in the interim already written. Any urgent mentioning, then
Item 60.
the rest of the matter will be rolled over.
Item 68.
Adjournment.
No, not actually.
Adjournment, then it will roll over. Don't say. It will be rolled over.
But that dispute, settled.
So it will be rolled over.
Come in the next week or?
No, I think next week, rolled over. From Monday onwards, it will be rolled over.
Not tomorrow.
Huh?
Item 76. I'm filing the counter.
76.
76.
You need a longer date.
No, I'm filing my counter today, I'm serving a copy and filing the counter today.
So after 2 weeks?
Yeah.
76 after 2 weeks, you know? His counter, Mr. Mukherjee submits that he will file the counter by today, by tomorroor. Regardless, within 2 days, advance copy be supplied to the respondent, leaves the matter for final disposal after over 2 years.
Interim order to be.
Interim order to continue, yes. Wait, see, I am for the 1 minute, you are appearing in this cases.
Okay, 76, all the three matters, same.
Yes, 76. Senior, age wise senior and order wise senior. Yes.
Age wise definitely might has a preference.
Yes.
But 77.
77, yes.
I request to repeat it on Monday because it's
Monday you will take it, but it will not be heard.
He will adjust
and give it so that it can be heard. Adjust and give it. Let him give little time. Because in the hurriedly, if you insist, he gives the time, it doesn't reach.
let it be repeated next week, as your lordship, right?
He will adjust in next week. Right. Because all the matter which are not taken up today will be adjusted next week, depending upon the availability. But next week it will be accommodated. Any mentioning, sir, you?
No, madam, I don't know, 75, I wanted to mention. Wait till next week.
Any urgent thing if you want to say anything, it's all right. Okay.
May I mention item 50 or 6?